Your Honor, we are now live streaming and you may proceed when ready.
Okay, let's get this show on the road. This is round 4, the final round of the Denver Adams Broomfield Regional High School Mock Trial Tournament. And we have Team BB on the prosecution and Team KK on the defense. My name is David Arkell. I'm your judge this afternoon. I'm not a real judge, but I am an attorney, and I have been volunteering as a judge for mock trial for probably 10 years, 12 years maybe. And I've been a judge, I've been a scoring panelist, I've been a coach, and I've been a parent for mock trial competitors. And I keep doing this. I haven't been fired yet. I keep doing it because I enjoy it, and I really believe in this program. It's extremely valuable for the kids and for me to have to get up to speed on the rules of evidence once a year for these tournaments. I'm going to go through some, I hope quickly, some introductory matters that the association requires. Let me see, I think we've modified this because of the Zoom platform. Let me first of all just, you all know this, but pay attention to your time limits. If you exceed your time for your phase of the process and you get a signal from your timer, just stop. Don't keep going, because the scoring panelists have been instructed that if a team goes over its time, they they don't have to, but they can mark you down for that to reduce your score. And while we're talking about timers, do we have one timer from each team with us?
Yes, Your Honor.
Yes, Your Honor.
Okay. Will you stop me if you've heard this, but what I would like you to do is, as each of the teams gets close to the time limit for that phase, would you periodically, say beginning at either 4 or 3 or even 2 minutes, turn on your video and flash a card or whatever you have that says 3 minutes or 2 minutes or 40 seconds left to go, or post that on your screen. But go ahead and do that so there's some visible indication of what the time limit is. And that'll be helpful to me too, and probably the scoring panelists as well. Let's go ahead and do the swearing in now. First of all, let's swear in the team members. Would you all please raise your right hands? Team members, do you promise that the presentation you're about to give will faithfully, excuse me, and truthfully conform to the facts and rules of the mock trial competition? Okay, thank you. Scoring panelists, will you please raise your right hands? Do you promise to adjudicate this mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of mock trial competition?
I will.
Yes, Your Honor.
Thank you. Witnesses, please raise your right hands. Do you promise that the testimony you're about to give will faithfully and truthfully conform to the facts, procedures, and rules of the mock trial competition?
Yes, I do.
Okay, thank you. And for the witnesses, I'll ask on both teams, I'll ask it now, but it'll be for both teams. When you take the stand virtually here, just remember that you are under oath. You've previously been sworn. And I will not remind you of that. I'd like you just to recall that prior to your testimony. Okay, let's go through the introductions. I'd like the team members, starting with prosecution's attorneys, to identify yourselves by your real name and by the role that you will have in this proceeding today. So starting with the prosecution, please introduce yourselves.
Good afternoon, Your Honor, ladies and gentlemen of the jury. My name is Liam Slavin. I will be a prosecuting attorney conducting the cross-examination of Detective Jordan Markowitz, as well as conducting the cross-examination of Avery Becker. I will also have the privilege of delivering the closing statement today.
Thank you.
Good afternoon, Your Honor, members of the jury. My name is Mackenzie Dana. I am also a lawyer for the prosecution. I will be giving the opening statement. I will be directing Alex Cifuentes, and I will be crossing Blake Van Owen. Thank you.
And good afternoon, Your Honor, and ladies and gentlemen of the jury. My name is Kyle Branson, and I'll be a prosecuting attorney crossing Ms. Taylor Perkins and directing Mrs. Kyle Kuzak.
Who will be doing the opening for the prosecution?
I will.
Okay, thank you. I missed that. Okay, prosecution witnesses, please introduce yourselves.
Alrighty, good evening. My name is Emily Bell, and I will be assuming the role of Jordan Markowitz.
Good afternoon, Your Honor, and members of the jury and opposing counsel. I'm Riley Falk, and I will be playing Kyle Kuzak.
Kyle, I'm sorry, Riley.
Hi, good afternoon, Your Honor, members of the jury and opposing counsel. I'm Maura Lorden, and I'll be playing Alex Cifuentes.
Okay, we're getting a lot of feedback, both for Mara and Riley. And let's see how it turns out when you're actually speaking, but we'll need to do something about that if it persists. Okay, will the defense please introduce yourselves?
Good afternoon, Your Honor, opposing counsel and members of the jury. I'm Greta Batchelor, attorney for the defendant Avery Becker, who will be appearing virtually today via Zoom. I'll be performing the opening statements, conducting the direct examination of Taylor Perkins, and the cross-examination of Kyle Kuzak.
Thank you.
Good afternoon, Your Honor, members of the jury. I'm Sanaa Kennedy. I'm the attorney for defendant Avery Becker, and I will be directing Avery Becker and crossing Alex Cifuentes.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Katie Jack, and today I will be crossing Detective Jordan Markowitz and directing Professor Blake Van Owen. I will also be delivering the closing arguments for the defense.
Thank you. The defense witnesses, please.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Alexandra Williams, and today I am Avery Becker.
Good afternoon, Your Honor, and members of the jury. My name is Madeline Komiak, and I will be playing the role of Taylor Perkins.
Good afternoon, Your Honor, members of the opposing counsel, ladies and gentlemen of the jury. My name is Cassie Kulig, and I am Blake Van Owen.
Okay. Thank you. Let me see. Does either team, starting with the prosecution, have any pre-trial matters that you'd like to bring to the court's attention?
Yes, Your Honor. Your Honor, we ask that all stipulated facts be moved into evidence.
Any objection from the defense?
No, Your Honor.
Okay, so ordered.
Your Honor, we ask that we can assume that the jurors, opposing counsel, witnesses, and you yourself have the exhibit packet so that we can enter evidence by referring to the exhibits by their number.
Any response from the defense?
No, Your Honor.
Okay, well, what we've been doing is having either counsel or the timekeepers use screen share to display the exhibits on the screens, on our screens, when they've been first brought to our attention prior to admission. And that has worked very well. Is that something we can do?
Yes, Your Honor, we can do that.
Okay, defense, is that available to you also?
Yes, we'd like to do that, Your Honor.
Okay, let's do that. And as a follow-on to that, once the exhibit is admitted, if it's admitted, if it's on our screens because of share screen, once it's admitted, its presence on share screen will constitute publication to the jury and tendering it to me. So you don't have to go through that stage. You don't have to say anything about that as long as the exhibit is still on share screen. Does that make sense? Is that acceptable?
Yes, Your Honor.
Katie?
Yes, Your Honor.
Okay, thank you. Okay, any other pretrial matters?
Yes, Your Honor, we have one last thing. We ask for permission for the timekeeper to remain on screen at all times if they so choose.
Response?
As long as it's their choice, then the defense is fine with that, Your Honor.
Okay, so ordered. Is that okay with the timekeepers?
Yes, Your Honor.
Okay, your choice as to whether you want to or don't want to remain on the screen. And it doesn't make any difference to me.
Honor.
Okay. Let me just mention, well, I'm sorry. Do you have prosecution? Do you have any further pretrial matters?
No, Your Honor.
Defense, do you have any pretrial matters we haven't already covered?
Yes, Your Honor. We'd like to address one more thing, and it's that the defense asks to remain seated during openings, closings, and examinations of witnesses.
Response?
No objection, Your Honor.
Okay, well, either team can stand, either any team member can either stand or sit during any time you're speaking, whatever you're most comfortable with. It doesn't matter to the court in this context. So it's so ordered. Any other pretrial matters, defense?
No further pretrial matters, Your Honor.
Okay. I'll just mention one thing. It's kind of a personal matter. I have a hearing defect and I wear hearing aids, and sometimes they work as well as Zoom does, and sometimes they don't work at all. But on occasion, I may have a little trouble hearing, even in this platform. And so if I ask you to repeat something, it's just because I happen to have missed it. It doesn't have anything to do with your presentation. It's just one of the things I need to live with. And I will mention that my hearing loss is most acute in the range of women's voices. And sometimes that's not such a bad thing. But in this context, I would appreciate if the women contestants, witnesses, and attorneys could keep that in mind a little bit and try to speak as distinctly as possible so that I don't have to interrupt things to make sure I've heard it correctly. Okay, with that, are we ready to proceed? Prosecution?
Yes, Your Honor.
Okay, please proceed with your opening statement.
All right, I will begin now. Good afternoon, Your Honor, opposing counsel, ladies and gentlemen of the jury. We are here today to establish the truth, and in doing so, promote justice. We are here to ensure that no wrongful action goes unpunished, to ensure that the law is upheld. Today, we look to deliver justice for the actions of Miss Avery Becker. Miss Becker was a naturally gifted lawyer on her mock trial team, a gift that she took great pride in. There is no crime in being proud of your achievements and talents, but such pride can easily turn fatal. It's beyond believable. We've seen such a downfall of many people, both historically and fictionally. For instance, Sophocles' Antigone. The King Creon is a confident ruler, given the throne after a war in which his nephews-in-law died. He decides to only bury the brother Euripides, not Polynices. Antigone, their sister, is shocked by this act of disrespect and goes out to bury her brother. And when she is caught, she stands strong in her conviction that what Creon chose is wrong. Creon, his pride wounded by her calling him out and disobeying his orders, imprisons Antigone to send her to her death. His fatal flaw is pride, blinding him from his mistake, causing him to kill his own niece and drive his closest family to death. Miss Becker is our Creon, and Mackenzie Brackman our Antigone. She could not stand when Mr. Brackman told her that her lack of work ethic was harmful to her team and herself, regardless of her natural talent. He wounded her pride when he called her out, like Antigone did Creon, in front of the whole team. Pride became her fatal flaw as well, causing her first to lash out and then kill Mackenzie Brackman. It is our duty to ensure that there's proper retribution for the death of Mr. Brackman. In order to prove that Miss Avery Becker broke into Mackenzie Brackman's house and murdered him on March 6, 2020, you will hear from 3 witnesses. First, you will hear from Alex Cifuentes. Ms. Cifuentes is a member of the mock trial team and a close friend of Miss Becker. She can testify to the tense relationship between Mr. Brackman and Miss Becker. Alex, as a friend of Avery, wants what is best for her, but above all, she wants the truth to be exposed. Alex held Mr. Brackman in high regard and desires justice for his tragic death. She will lay out Miss Becker's motive for killing Brackman with irrefutable evidence. Next, you will hear from Kyle Kuzak. She has 19 years of experience working with the Denver Police Department and is a certified crime scene reconstruction investigator. She will provide undeniable evidence proving that the incident was a burglary gone wrong that spiraled out of control as Miss Becker let her emotions get the best of her. Lastly, you will hear from Detective Jordan Markowitz. Markowitz joined the Denver Police Department 13 years ago and has served as a homicide detective for 7, making her expert opinion essential in this case. She will also provide solid, indisputable evidence, including video and cell phone records, that definitively incriminates Miss Becker. Ladies and gentlemen of the jury, it is imperative that you look at the facts as they are presented to you. Miss Avery Becker's case today will be nothing more than her cases in mock trial, a performance that must not fool you, for Miss Becker is, at her best, a performer. But the truth must not be stifled by a show, for what is not an elaborate, misleading production is the murder of Mr. Brackman, a man who wounded Miss Becker's pride, rendering him victim to her violent retaliation. The police have already determined that Miss Becker's fatal flaw led her to murder Mackenzie Brackman. Cell towers place her phone in the vicinity at the time of the murder, and the text messages between her and Ms. Cifuentes confirm her plan to break into Mr. Brackman's house. The evidence alone incriminates her. Miss Avery Becker has fallen victim to the ultimate fatal flaw, that of pride, leading her to commit actions of a knowing vengeance. If you look back at Antigone, Creon's fatal pride causes him to sentence Antigone to an unjust death. The sentence I want today is that of Miss Avery Becker, for she is guilty of the murder of Mr. Mackenzie Brackman. Thank you.
Defense, please present your opening statement.
Yes, Your Honor, I will begin now. Ladies and gentlemen of the jury, opposing counsel, and Your Honor, today you will see how the detectives in their investigation have cut too many corners. This investigation started off as a square, a blank canvas, but as the investigation went on, the detectives have cut so many corners that what you see here today is a circle, a hole. The prosecution has already told you, the experts in this case, but we will show you how they took shortcuts and made rushed assumptions. This is a tragic, tragic crime, a crime that Avery Becker did not commit. And this investigation has cut so many holes into itself that it has allowed the true killer to escape prosecution. Let me start off by introducing Avery Becker. She went to Colorado High School last year. She was on the mock trial team, and she was very good at what she did. But she didn't get along with the coach. You probably have quite a few questions about Avery, and you will see them answered today. But I can tell you right now, is Avery a perfect student? No. Is Avery a perfect person? No. Is Avery always calm and happy? Again, the answer is no. But does that mean she's any less human? You've all been angry and been a little bit too quick to act. She was mad and felt she was being treated unfairly, and she made a rash decision to take a marker and draw on a car. But that does not make her a murderer. She may have made that one mistake, but her only mistake was being an unruly teenager. She knew what she did was wrong, and after she had cooled down, she was trying everything to apologize. She knew the consequences of her mistake. After all, she'd been kicked off of the mock trial team that she loved so much. So why would she want to repeat her same mistake again if she knew the repercussions? These are some of the questions that we will be asking today. We will show you how Detective Jordan Markowitz, also known as Chief Corner Cutter, failed to investigate other suspects, even though there are other questionable characters in this case. We will question Alex Cifuentes, the rival of Avery on the mock trial team and the friend of another potential suspect. We will also question Kyle Kuzak, a crime scene expert who made some questionable assumptions when investigating the crime scene. But today you'll get to hear from Avery herself. You will see in her what the investigation has failed to see. A young girl who made the mistake of being angry and grabbing the wrong marker. You will hear straight from her where she was, and we will ask Taylor Perkins, a friend of Avery, where the two of them were that fateful day. You will hear about the alibi that the detectives and opposing counsel have failed to investigate or even consider. We are going to show you evidence about how this investigation was conducted improperly, including the testimony of an expert witness who knows how crime scenes should be investigated. There are also key pieces of evidence in this investigation that lack proper explanation or reason to them. The murder weapon, a large chef's knife, was found on the scene and was automatically assumed to have belonged to the victim simply because it might have fit in a knife block. This is strange for many reasons, the first of them being that there are a pair of large scissors next to where the victim was sitting if he had wanted to defend himself. And this knife matched no other knives in this house, even though there is a clear pattern that most of the knives are part of a set. You might be thinking, why is it so important where the knife came from? But this is a key piece of the crime scene that the police failed to properly investigate. And we're going to show you how someone with a motive to kill Mr. Brackman brought the knife to the crime scene with the intent to kill him that day. We will be introducing a possible suspect today, someone the police failed to investigate. Our suspect is the former client of Mr. Brackman's who was out for revenge. We have him on tape even saying so. This person was also absent for school the day of the murder, and he would have known where Mr. Brackman's house was. This person is a friend of Mr. Cifuentes, Ms. Cifuentes, and could have potentially gained access to Avery's phone to frame the murder on her. But alas, this is another corner cut in the detective's investigation. After all, they were so lazy that they stopped looking for suspects after Avery. It's important to remember that in this case, there's zero evidence putting Avery herself at the crime scene. There's no one who saw her there, no video footage where you can identify her. There's evidence of her phone near Mr. Brackman's house and suspicious photos of supposed screenshots claiming she was going to the crime scene. But that evidence shows much reasonable doubt. And since the police failed to investigate Avery's alibi, they have no way to refute her and Taylor's statements. This case centers around a few key hours where someone broke into Coach Brackman's house and intentionally or unintentionally killed him. But it couldn't have been Avery Becker because she was at the mall with her best friend searching for her lost phone. Unfortunately, the police didn't even consider this. They didn't even consider a lot of things. They just cut so many corners that you will not be able to tell what is fact and what is assumption. This investigation has tried to shove Avery into this crime. They have tried to put a square peg in a round hole. You will ask yourself many questions today, but I would like to ask you one right now. Can they prove beyond a reasonable doubt that Avery was the one who broke into the house and killed Mackenzie Brackman?
Okay, thank you. One thing that I forgot to mention in the pretrial matters is that I will try to allow some time between each of the phases of this trial so that the scorekeepers can stay current on their scoring. And I hope it's no more than 30 to 45 seconds or so, but I will pause, and I don't want you to, that's what's going on there. It's important to this process that the scorekeepers stay current and are accurate, and they're happy with their scores in one phase before we go on to the next phase. They need to stay current, and I give them that opportunity. And I would just say to the timekeepers, that time is mine. It is not, should not be debited, I guess, to either of the teams. So turn off your timers during those short pauses during the course of this proceeding. Okay, are we ready to proceed with the prosecution's first witness?
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Please proceed.
Good afternoon, Ms. Cifuentes. Let's begin your direct examination. Say your name and spell it for the record.
I'm Alex Cifuentes, Sifuentes.
All right, let's begin with the direct questioning. Tell me a little bit about yourself.
I'm Alex. I'm a senior in Colorado High School and an active participant on our mock trial team.
And what was your experience in mock trial?
I love the mock trial team like a family. Nothing made me prouder than to be a part of it.
How did you get involved with the team?
My best friend and defendant, Avery Becker, actually introduced me to it.
What is your relationship with Ms. Becker pertaining to the mock trial team?
Avery and I both excelled on the mock trial team, and ultimately competing with or against each other made us stronger opponents.
Are you aware of the rumors about you and Ms. Becker?
Yes.
What are they?
Unfortunately, due to the competitive atmosphere of mock trial, it's rumored that we are secretly enemies.
Are they accurate?
Not at all. If it weren't for these circumstances, I would find the claims comical.
What is your relationship with Mr. Brackman?
I loved Mr. Brackman. He was a great mock trial coach who genuinely loved what he was doing. I looked up to Brackman more than I did my own father.
I'd like to turn your attention now to the aftermath of the regional tournament. Explain to the jury what happened after the regional tournament.
Mr. Brackman told Avery that she didn't deserve all the awards she was given because of her lack of work ethic.
To the best of your knowledge, how did Ms. Becker respond?
She stormed out and threw a hissy fit. She vandalized Brackman's car with the words "Worst Attorney Award" in permanent Sharpie. I can't say that I was surprised.
Prior to the outburst, did you see where Ms. Becker got the Sharpie?
Yeah, Avery took the Sharpie from an easel of paper. There were pens and pencils, but no dry erase markers.
To the best of your knowledge, how did Mr. Brackman respond to the vandalization?
Fortunately for Avery, he didn't press charges, but he kicked her off the team for good.
And did that affect the team?
Yeah, she was a great actress and performer and often brought us to success, so having her gone was a real disappointment.
Did Ms. Becker attempt to get back on the team?
Yes.
Your Honor, permission for co-counsel to share the screen for Exhibit 14.
Yes. And timekeepers, while we're waiting for the share screen to operate here, this time should not be charged to either side as well during any technical delays that we have.
All right, are you familiar with these? What are they? Mr. Fuentes, you are muted.
Sorry about that. Yes, I do recognize these.
What are they?
This is a text message conversation between myself and Avery Becker.
Why did you send in the screenshots instead of giving your phone?
Well, my phone had a bad battery and I left it in charging at my house when I went for the interview.
And why do we not have the phone today?
Well, obviously I traded it in and I offered to come back in with the old phone, but I was told that the screenshots were sufficient.
Have these screenshots been altered in any way since you last saw them?
No.
And how do they pertain to the case?
They show Avery's reaction to getting kicked off the team.
Your Honor, I believe I have laid sufficient foundation and move that Exhibit 14 be entered into evidence.
Any response?
Your Honor, if I may, I would like to ask that prosecution shows the full exhibit.
Of course.
Is it possible to reduce the exhibit a little bit so we can see it all on one page,
Yes, it is.
one screen? Is that legible now? No, I guess if we can't, it doesn't look like we can do that. So I guess we'll just have to deal with it in two bites here.
Is this sufficient, opposing counsel?
If you could scroll up to the first page of Exhibit 14, that'd be great. A little more, thank you. All right, that's all.
I'm sorry, is there a response to the offer of Exhibit 14 into evidence?
No, Your Honor.
Wonderful. In that case, we'll continue.
Okay, wait just a second. Exhibit 14 shall be admitted into evidence for all purposes. Please proceed.
So, Mr. Fuentes, what are the messages about?
Avery texted me she wanted to get back on the team and she seemed pretty desperate. At that moment, Avery would have done anything to get back on the team and start fresh with Brackman, but it was a lost cause.
And are you aware of the rumor pertaining to Miss Becker's phone?
Yes.
What is the rumor?
Some people believe I stole the phone to give to Blair Rollins, but up until the morning of March 6th, I was on Avery's side.
Let's focus a bit more on Blair Rollins. What is the nature of your relationship with Mr. Rollins?
I barely know Rollins. I might have had a few classes with him, but he was just another face in the hallway.
Would you give the phone to Mr. Rollins?
No, like I said, I barely know him and would never intentionally put Mr. Brackman in danger.
No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. All right, if I may begin.
You may.
Good afternoon, Mr. Fuentes. My name is Sanaa Kennedy, and I am representing Avery Becker. You were friends with Avery Becker, correct?
Yes.
And you're on the Colorado High School mock trial team with Avery Becker?
Correct.
You would consider yourself and Avery to be good friends, right?
Yes.
And Avery is a good attorney?
Yes.
Good at thinking on the fly for crosses and closings, you said?
Could you say that again?
Good at thinking on the fly for crosses and closings, you said?
Yeah, she was a great performer.
So she won the award for best attorney, isn't that right?
Yes.
That annoyed you, didn't it?
wouldn't say it annoyed me. I mean, sometimes it can be frustrating, but at the end of the day, I have to remember that as best friends, we're on the same team, regardless of mock trial rules.
But then again, you kept bringing up how Avery would always do great on crosses and closings without trying, and how you thought it was unfair and how she lucked out. Is that correct?
I wouldn't necessarily say she lucked out every time. I think she did have real talent, and she did do really well on mock trial.
Let me ask you this. You were at the mall with Avery Becker at the Fry Shack before the day of the murder, correct?
Correct.
Objection, Your Honor. That is out of the scope of my direct.
Response?
I'll just move on.
Please proceed.
All right. Do you know that Avery had lost her phone after she got cut from the team and had never found it?
Am I aware of that currently?
Yes.
Yes.
But you testified that Avery had texted you after seeing her after the Fry Shack in your statement, correct?
Correct.
If Avery didn't have her phone, it would have been impossible for her to message you, wouldn't it have been?
I mean, I can't really testify for Avery and her phone, but yeah.
But it was in your testimony that you did receive a message from Avery in your statement, isn't that correct?
I did receive a message from Avery.
All right. Lastly, I'd like to ask you about something in Exhibit 14. Your Honor, permission to present my screen to which has previously been marked as Exhibit 14.
Please share screen the exhibit.
Can you see the exhibit?
Yes.
All right. You do recognize this exhibit, correct?
I do.
All right, and you sent these messages after the Fry Shack, correct? Did you hear my question?
Yeah. Did you not hear me?
Oh, no, sorry.
Oh,
Could you
okay. No,
repeat it?
you're good. I said correct.
All right. Okay. And you, sorry, and your phone had been left charging when you went to the station to share it with the detective?
Yeah, it had a horrible battery and wouldn't last long.
All right, so it's probably done charging by the time you got home, correct?
There's no guaranteeing that. The battery was broken.
Objection, relevancy.
Response?
This will lead to a more relevant question.
I'm sorry, what was your response?
This will lead to a more relevant question later on.
Reply?
Sorry, could you repeat that?
No reply, Your Honor.
Okay, overruled. Please proceed.
All right. Okay. Would you like me to repeat the question?
Yes.
Okay. So your phone was probably done charging by the time you got back from the station, correct? Considering the fact that you left it charging.
I mean, I'd assume so, but the battery was completely broken, so I couldn't really tell you.
All right. Your Honor, I have no further questions.
Any redirect?
No, Your Honor.
Okay, thank you. Prosecution, please call your next witness.
Yes, yes, Your Honor. Prosecution calls Mrs. Kyle Kuzak to the stand.
Please proceed.
I'm not quite seeing Mrs. Kuzak.
Counsel, my computer camera is not working. I will try to get it to start working.
Okay, that's all right. If not, I can just.
Let's
Okay.
Okay, here we go.
Okay.
Please proceed.
Good afternoon, Ms. Kuzak. My name is Kyle Branson, and I'll be doing your direct questioning. So first, can you please state your name for the record, spelling the last?
Of course, it's Kyle Kuzak, Kuzak.
Now, Ms. Kuzak, can you please tell us why you were called to the stand today?
I'm here to offer up an analysis on the homicide of Mackenzie Brackman.
And how were you involved in that investigation?
I'm a Colorado Bureau of Investigation certified crime scene reconstruction investigator, also known as a CSR.
And what does that job entail, Ms. Kuzak?
I investigate crime scenes including home invasions, burglaries, homicides, domestic violence, and fatal accidents.
And exactly how long have you been a crime scene reconstruction investigator?
I have 19 years of experience, and I've spent the last 3 years of my tenure with the city of Denver.
Okay, and are you a Denver police officer?
I am not. I am a civilian employee of the Denver PD.
Okay, and now let's move on to the case at hand. What were your first impressions at the scene?
The events and evidence did not indicate a complicated fact pattern.
So since you didn't think it indicated a complicated fact pattern, did that let you affect the way that you conducted your investigation based on your simplistic view of the facts?
Absolutely not. I assume that every case is going to trial, so I always conduct a thorough investigation. Secondly, I document and organize all the events with a mindset of reconstruction.
Perfect. That seems a little complicated. Can you please break that down for the jury?
Of course, I look at everything on scene as a potential clue, and I rebuild the events in a sequence of context.
And why is that important?
These principles ensure a concise and accurate flow of my work, which I approach in 2 parts.
And what are those 2 methods that you use?
First, I use the Bevel and Garner's 7-step methodology, and next I use the 5 CSR steps in reconstruction.
Perfect. Thank you, Your Honor. I believe I have laid sufficient foundation and move to have Ms. Kuzak entered as an expert witness in crime scene reconstruction.
This witness has been tendered as an expert in the area of crime scene reconstruction.
Correct, Your Honor.
Any response?
No, Your Honor.
Okay, this witness shall be deemed qualified under Rule 702 in the area of crime scene reconstruction and may testify pursuant or through opinion evidence pursuant to that rule. Please proceed.
Perfect. Thank you, Your Honor. And now let's move on to the background, or let's move on to back to the investigation, Ms. Kuzak. Please start from the beginning of your investigation at the scene.
Of course, I visited the 444 South Flower Street after it was processed by other members of the crime lab.
And what did you do once you were on the scene?
I reviewed all police reports, including the photographs from the scene and the 4-ring zoom video cameras.
And after this?
I created a witness tracking spreadsheet to summarize key points of information of both witnesses and suspects.
And where can we find this spreadsheet?
In Exhibit 17, it is a copy of the spreadsheet that I have prepared for this case.
Perfect. And what's so important about that spreadsheet?
Well, it helps visualize the methods I use, and it helps corroborate or refute statements from both witnesses and the evidence that they supply, because it always has a chance to be inaccurate. But objective evidence is never inaccurate.
Perfect. Thank you. Timekeeper, I ask that you please share Exhibit 17 on the screen for everyone to see. Thank you. Your Honor, I believe I have laid sufficient foundation and move to have Exhibit 17 entered as evidence.
Any response?
Yes, objection to hearsay. This document contains out-of-court statements asserted for the truth of the matter.
Response?
Although this is true, Your Honor, we have previously admitted Ms. Kuzak as expert, and this falls under one of the exceptions to hearsay, because it is summary by an expert.
Reply.
No reply, Your Honor.
Exhibit 17 will be admitted for all purposes. Please
Perfect.
proceed.
Thank you, Your Honor. Now, Ms. Kuzak, continue walking us through your steps, please. What's next?
Of course. Next, I create a physical evidence sheet and a flowchart to show key physical and chronological relationships.
And what benefit does that serve?
Well, visual aids like these are helpful in explaining the case to others and to place the events into a stream of context.
And how beneficial are those visual aids?
They're extremely beneficial. Organizing these photographs into a spreadsheet highlight the key chronological order and relationships and clear up any confounding details.
And now, before we address the homicide, I'd like to address the anomaly you noticed in your report, which were the corrupted photographs.
Of course, digital files for the photographs of the crime scene did become partially corrupted, but that was only after I already reviewed them.
So if it was after you already reviewed the photos, did it impact your investigation in any way?
Not one bit.
Perfect. Now, please give me your initial observations once on the scene of the homicide.
Of course, in the afternoon of March 6, 2020, perpetrator matching both the height and build of the defendant approached the house.
And how did you know the perpetrator and the defendant share physical similarities?
Through the 3 Ring cameras.
And could you please explain how the perpetrator entered the house?
Of course, the perpetrator initially stepped onto the front porch, which was captured by the first Ring camera, and then proceeded to the south side of the residence, which was outside of camera range. An additional security camera picked up the defendant opening up the fence gate, and the perpetrator was captured 10 seconds later, opening the sliding glass door and entering the residence.
Perfect. And what were your observations once inside the house?
Scuff marks near the door show a struggle in the kitchen, and immediately to the right was a drawer found with small knives inside, but more importantly, there was a knife block on the counter where one large chef knife had been missing.
Perfect. And what's the significance of that knife block?
The missing knife, there was a missing knife, and that missing knife was a large chef knife, which happened to be the same knife that was recovered from Mr. Brackman's body.
Perfect. And where can we see images of this knife block and the knife?
In Exhibit 8.
Perfect. And timekeeper, could you please show everyone Exhibit 8 with screen share? Perfect. Thank you. And Judge, I move to have Exhibit 8 admitted as evidence.
Response?
Objection, Your Honor. Counsel has not laid the proper foundation to admit this exhibit into evidence.
Reply?
Your Honor, I believe I have laid a sufficient foundation as I explained how it was used in Ms. Kyle Kuzak's investigation.
May I reply, Your Honor?
You may.
Counsel has not determined if this is a fair and accurate representation of the photo that was taken at the crime scene.
Okay, I'm going to sustain the objection for now, but I will provide leave for counsel to lay some additional foundation for this exhibit.
Thank you. Ms. Kuzak, is this a fair and accurate copy of the photographs taken at the crime scene?
Yes, it is.
And do we know who took these photographs?
I believe other members of the crime lab took those photographs.
Perfect. Thank you. Now, Judge, I believe I have laid sufficient foundation and I move to have Exhibit 8 entered as evidence.
Response?
No objection, Your Honor.
Exhibit 8 will be admitted into evidence for all purposes.
Perfect. Thank you, Your Honor. And one last question for Ms. Kuzak. The conclusions that you came today as an expert in crime scene reconstruction, from all of the evidence that we've seen, do you believe that this is the most accurate representation of what occurred on March 6th?
Objection,
Yes,
leading question.
I'm sorry, what was your objection?
Leading question.
Response?
Your Honor, this is not a leading question. The witness, it's a yes or no question, and the witness has the right to say either.
Objection overruled.
May you please repeat the question?
Yes, Ms. Kuzak, the conclusion that was based off of the evidence you reviewed today do you believe that it is the most likely what occurred on March 6th?
Yes, I do. I believe it is the most accurate response to the evidence that we could get.
Perfect. Thank you. And that'll be all for today, Your Honor.
Cross-examination?
Yes, Your Honor. Ms. Kyle Kuzak, may I begin?
Of course.
Let's talk about the alleged murder weapon previously entered into evidence as Exhibit 6. May I have permission to share my screen to show Exhibit 6?
Of course.
Can you see this exhibit?
Yes, I can.
Did you measure the size of this knife?
Yes, I did.
And what was the size of this knife?
It was 19 centimeters.
Okay, and you claim this knife came from the Brackman's home, correct?
Yes, we claim it came from the missing knife in the knife block on the counter.
Okay. Permission to share my screen to show exhibit what has been previously marked as Exhibit 8. Your Honor, may I have permission to share my screen to show Exhibit 8?
Certainly.
This is the knife hole that you were talking about, correct?
Correct.
Did you measure the hole in the knife block?
It is evidence shows that the knife does match a perfect fit for the knife block.
Did you ever put it in the knife block to test?
Well, as evidence, we can't tamper with it, but it does.
So you never put it in the knife block?
As evidence, we are not able to put it back in, but we measured it and it happens to be the same fit, which gives us conclusion to using the knife.
Did you ever measure the size of the hole in the knife block?
Again, we determined that it was.
Excuse me, this is a yes or no question. Simple yes or no is all that's required.
We determined that it is the same size.
But did you measure the hole in the knife block?
We measured the knife and the knife fits into the hole in the knife block.
But how could you know if the knife block fits in the hole if you didn't measure the hole?
Because it is probable that the knife fits into the hole, because as you can see, it is a perfect match with the knife block on the counter.
Okay, let's move on. The knives in the knife block, they do not match the style or the brand of the knife that you have identified as the murder weapon, correct?
That is correct.
And so you don't even know if the knife would have belonged there in that hole.
Well, evidence suggests that it did come from that knife block, and to answer that they aren't the same brand, someone could replace a knife for many different reasons, and we cannot draw a conclusion for why that reason would be, but evidence suggests that it is the knife used to kill Mr. Brackman.
Okay. Let's move on. You also took pictures of the crime scene of a drawer full of knives. Permission to share my screen to show what has been previously marked as Exhibit 7?
Yes.
Do you recognize this photo?
Objection, Your Honor. I believe Exhibit 7 has actually not been entered as evidence yet in today's trial.
I think that's where we're going. And it is, in case there's any question, it is acceptable to the court to display the exhibit that's being referred to through the share screen process as part of the admission process. So this is proper.
Okay.
Do you recognize this photo, Ms. Kuzak?
Yes, I do.
Is this a fair and accurate copy of the photo that you took or your fellow members of the crime scene team took at the crime scene?
Yes, it is.
Motion to enter into evidence exhibit what has been previously marked as Exhibit 7.
Response?
No objections here, Your Honor.
Exhibit 7 will be admitted for all purposes.
Okay, Ms. Kuzak, do you notice that there's several different brands of knives in this drawer?
Yes.
And that there are many different styles of knives in this drawer?
Yes.
and that none of the brands nor the styles matched the knife in this drawer. Matched the knife found at the scene of the crime that you presume to be the murder weapon.
Well, as seen in the drawer, none of those brands really of the knives match each other anyways, so it is still probable that the knife that killed Mr. Brackman did come from the knife counter, the knife block.
Okay. You never tested the knife for DNA evidence, did you?
No, because the defendant
So,
was
and you
wearing
never tested it for fingerprints either?
the defendant was wearing gloves.
The defendant or the intruder?
Avery Brecker, our prosecutor, was wearing gloves, which means there would be no
But can you
DNA.
identify her as the person who is the intruder in the home based on the video evidence?
Yes, actually, through the 3-ring zoom cameras, you could see
You
the
can
exact.
identify her specifically as that intruder, even though she is wearing the intruder is wearing a mask and clothing to hide their identity.
Well, if we identified her specifically, there would be no trial today. So evidence suggests that the height and build does match Avery Becker.
But the height and build, not the specific identity of the intruder.
The height and build and the evidence through the 3-ring zoom cameras or ring cameras do show that it was the exact height and build of Avery Becker. And if it was concrete evidence, we would not be here in trial trying to prove that.
So this is not concrete evidence that Avery Becker was at the crime scene based solely on the video footage.
Well, the video footage plus the struggle plus the broken plate.
But based solely on the video footage, you cannot identify the intruder.
We can most accurately identify the intruder as Avery Becker today.
Based solely on the video footage?
The video footage, the struggle, the broken plate, everything.
I'm asking
plays
solely on the video footage. You're answering based on other parts of the crime scene. I'm asking solely about the video footage. Can you identify the intruder based solely on the video footage?
We can identify that the intruder was exact height and build as our prosecutor today, Avery Becker.
Okay. But you cannot identify specifically that you cannot see Avery Becker under that mask or under the clothes.
No, you cannot, but the height and build do show that it was Avery Becker, as evidence suggests.
Okay. Moving on to your spreadsheet, which has been marked as Exhibit 17. This is the spreadsheet that you used to organize witnesses, is it not?
It is.
Okay. Permission to share my screen to show what has been entered into evidence as Exhibit 17.
Yes, you may. And counsel, just as a procedural matter, just ask that the exhibit be shown. You don't need my permission to have it shown.
Yes, Your Honor. I'll do so in the future. And in this spreadsheet, who did you identify as the person who first found the body?
We identified that other members of the crime lab first found the body as they responded to the scene before I could.
But in this document, we can see Mitchell Josiah is the person you named as the person who found, as the neighbor to the east of the victim's residence who called 911 to report the victim lying on just inside the porch. So wouldn't that be the person who identified the body?
We don't know that for sure. As I said, other members of the crime lab investigated the scene before I could get there, such as Markowitz.
But this is the person right here, Josiah Mitchell, that you identify as the person who found the victim's body, correct?
It just says that he was laying on/inside the porch, yes.
So he's the one who called 911 to find the body, contradicting your previous statement that it was members of the crime scene team.
Well, he was the one who, yes, called 911, but the members of the crime lab did go to the body first before I could, and they were the one who processed the information first.
Okay. So the person who first found the body, you would agree, is the neighbor to the east of the victim's residence, Josiah Mitchell, correct?
Josiah Mitchell did call 911, but again, the first person who actually inspected the body and looked at it thoroughly for our investigation was other members of our crime lab.
Okay. let's move on. In your investigation, would you say that you come to what you say is the best explanation of events?
Yes, it is the most accurate conclusion that we could come to.
But there could be other explanations for this crime.
Well, there's always other explanations, but with my 19 years of experience, this is the best evidence that we could conclude.
Okay. And based on the video evidence, you cannot confirm that the intruder specifically is Avery Becker.
Evidence suggests that it is Avery Becker due to the height and build shown through the evidence of the 3 Ring cameras.
But it could be someone else because many people would match that height and build, correct?
Yes, that is true that many people have that, but evidence suggests that it is Avery Becker, our prosecutor today.
Okay, no further questions, Your Honor.
Any redirect?
Just a brief one, Your Honor.
Please proceed.
Okay, to begin, Ms. Cusack, you state that the knife most likely came from the house, correct?
That is correct.
And that conclusion was come to using your 19 years of experience, logical reasoning, and other evidence seen on the crime scene, correct?
Correct.
Okay. Now, moving on to Avery Becker, just to confirm, the Ring cameras show the height and build of Avery Becker, someone with the height and build of Avery Becker entering the crime scene, correct?
Yes, it does. The height and build perfectly match our defendant today.
Okay. And using your 19 years of experience and expert testimony again, using the other evidence as well, you believe that that was Miss Becker entering Mr. Brackman's home, correct?
Objection, leading question.
Response?
Again, it's not a leading question, Your Honor. Ms. Cusack has every right to say yes or no to this question.
Please rephrase your question.
Okay. I apologize, Your Honor. Ms. Cusack, using your 19 years of experience and all evidence gathered on and off the crime scene, you believe that the person entering the home was Miss Becker, correct?
Objection, this is still a leading question, Your Honor.
Please rephrase your question so it isn't a leading question.
Apologies again, Your Honor. Do you believe the person entering the house was Miss Becker?
Yes.
Okay. And that conclusion was come to using your 19 years of experience and evidence found on and off the crime scene, correct?
Yes, correct.
Okay, and that will be all for today, Your Honor.
Thank you.
Your Honor, may I ask for a quick recross?
Yes, if it's quick.
Okay. Ms. Cusack, you said that using both evidence off and on the crime scene, you identified the intruder as Avery Becker, correct?
That is correct.
But you only are entered as an expert in crime scene reconstruction, correct?
That is correct, but we can use any evidence available to make a conclusion.
But the evidence gathered off of the crime scene is not evidence that you were an expert in, correct?
I am an expert in crime scene reconstruction, and any evidence that goes into crime scene reconstruction is considered part of my expertise.
Okay, no further questions, Your Honor.
Okay, thank you. Prosecution, please call your next witness.
Your Honor, the prosecution calls Detective Jordan Markowitz to the stand. I will begin, Your Honor. Good afternoon, Detective Markowitz. My name is Liam Slavin, and I will be conducting your direct. Please state your name for the court, including the spelling of your last.
Okay, Jordan Markowitz, Markwitz.
Now, why are you here in front of the court today?
I was assigned to investigate the death of Mackenzie Brockman.
And what is your career, detective?
I'm currently a homicide detective with the Denver Police Department.
How long have you been active in the Denver Police Department?
I've been active for over 13 years.
Now, you said you were a homicide detective. How long have you fulfilled that role?
7 years.
Now, being a homicide detective with the Denver Police Department, do you have any specialized training in your field of work?
Yes, sir, I do.
What specializations, detective?
So I earned a cell phone technology and forensic data recovery certificate from the American Academy of Law Enforcement.
That's pretty impressive, detective. Now, have you utilized that specific training within your career?
Yes, I've utilized that training over the span of many years, and I constantly use it as a detective. I've downloaded the contents of cell phones for over 100 times, and I use cell phone data tower analysis in over 50 cases.
Detective, could you please tell us about the case of Mackenzie Brockman that you were assigned to?
So on March 6, 2020, a report was filed to the police department about some passed out person on the porch. Paramedics first arrived, and after the police were called in, I was called in.
And what did you see at the scene of the crime?
So I observed a open front door with the victim having been stabbed from behind, bled out from the back. I also examined the rest of the residency and documented the evidence and took photographs for the record.
Your Honor, I offer this witness, Detective Jordan Markowitz, as an expert in cell phone technology and forensic data recovery, as well as a homicide detective.
Okay, I'm sorry, cell phone data recovery?
Cell phone technology and forensic data recovery, as well as being a homicide detective.
Any objections?
Yes, Your Honor. May I have word of a witness?
You may.
You've never testified as an expert in forensic science, correct?
I've used forensic data recovery in over 50 of my cases that have gone to court.
But you've never testified as an expert, correct?
I have.
Where in your
In
statement?
over 50 cases.
You say that you used it, excuse me, you said that you used it in 50 cases. You did not say you testified as an expert, correct?
Correct, but as stated before, my experience within this field ties more into my expertise rather than prior omitted.
Okay. And in your career as a detective, you don't regularly analyze forensic evidence, do you?
On the contrary, as my career as a detective, I am constantly analyzing forensic data.
Okay. You've testified as an expert in cell phone analysis, correct?
That is correct.
How many times have you testified as an expert in that?
I've testified, although it's not specifically stated in my affidavit, I have experience with cell phone technology data analysis, and I also have field experience with cell phone data technology analysis as I'm constantly using it as a detective.
Okay. Your Honor, if a prosecution has not laid the foundation for a witness to be entered as an expert in anything except cell phone technology, this witness shouldn't be entered as an expert in forensics.
Response?
Your Honor, I believe I've laid sufficient foundation for Detective Jordan Markowitz to be entered as an expert in all three of those fields.
May I respond, Your Honor?
You may.
The foundation that was laid was about cell phone data and cell tower data, which was what was discussed in regards to the certification and the training. There was no discussion in regards to forensics.
Reply to that?
Your Honor, part of recovering forensic data is the detective's role of recovering cell phone technology. Those two things go hand in hand.
Okay, objection is overruled, and this witness is deemed qualified as an expert in cell phone technology and data recovery and homicide detective forensics, and may testify through opinion evidence pursuant to Rule 702.
Thank you, Your Honor. Let us continue, Detective. You said that you took pictures at the crime scene. Is this correct?
Yes, sir.
Let the record reflect that I am sharing my screen of what is previously been marked as a copy of Exhibit 2. Do you recognize this?
Yes, I do.
What is this?
This is a photograph of the victim I took at the scene of the crime.
Is this a fair and accurate copy?
Yes, it is.
Your Honor, I offer Exhibit 2 into evidence.
Any objection?
No objection, Your Honor.
Exhibit 2 will be admitted into evidence for all purposes.
Thank you, Your Honor. Now, as a detective, what can be inferred from this photograph that you took?
So clearly the victim was stabbed from behind as he is seen bleeding out on the floor.
And does your reviewing of this case, including all the evidence and the photographs that you took, indicate that the victim was stabbed while a burglary was being committed?
Yes, it does. The fact that the house had been disturbed and the victim died in the house suggests that the murder happened while a burglary was taking place.
Now, after taking that picture, did you notice anything else at the residence?
Yes, I noticed 2 Ring cameras located at the front and back of the residency.
Let the record reflect that I will be sharing my screen to present what has previously been marked as a copy of Exhibit 12. Your Honor, do I have permission to play this video?
Yes, you may.
Do you recognize this, detective?
Yes, sir.
What is this exactly?
This is a video from a Ring camera of Mr. Brockman's residency.
And did you obtain this video?
Yes, I did.
And has this video been altered in any way, shape, form, or fashion?
No, sir.
Your Honor, I offer Exhibit 12 into evidence.
Response?
No objection, Your Honor.
Exhibit 12 will be admitted for all purposes.
Thank you, Your Honor. Let's continue, detective. What does this video show to you?
So this video shows a person walk up to the back door, which was obviously unlocked, and the person then proceeding into the residence. The intruder is wearing a hoodie, Halloween mask, and gloves.
And what does this information that you've gained from the video suggest to you in your expert opinion?
So the intruder was planning on breaking and entering, as the gloves and mask suggest. This also clearly shows some form of criminal intent or mischief against Mr. Brockman as his residency, as the perpetrator is seen sneaking around the house.
Thank you, detective. Let's shift to a different area of your expertise. You were entered as an expert in cell phone technology, forensic data recovery, and being a homicide detective. Is this correct?
Yes, sir.
And you utilize these skills in your case?
Yes,
Objection leading.
Response?
Your Honor, I will rephrase the question.
Thank you.
Detective, did you utilize your expert skills within this case?
Yes, I did. So I used my training in the way that I could access the account details, call information, and records of the victim's cell phone.
Let the record reflect that I am showing a copy of sharing my screen of what has been previously marked as a copy of Exhibit 16. Do you recognize this?
Yes, sir.
What is this exactly?
So Exhibit 16 is a diagram I made that summarizes what the call detail record, or CDR, shows for a cell phone ID linked to Avery Becker, the defendant, with the route I believe Ms. Becker likely used to get to Mr. Brockman's house.
Is this a fair and accurate copy?
Yes, sir.
And just to clarify, you created this image, correct?
Yes, I did. It is part of my business practices as a homicide detective to take this extra step and make a CDR record.
Thank you, detective. Your Honor, I offer Exhibit 16 into evidence.
Any objection?
Yes, speculation.
Response?
I would ask opposing counsel to please clarify your objection. I'm a little confused on it.
Yes, there are 2 things. So first of all, the route taken is speculative. And secondly, I just want to clarify that you cannot say that this is a route that Avery took or indicative of anywhere Avery was. It's only indicative of the phone.
Your Honor, this is merely a picture, an image that the detective created as she's already been entered as an expert. So this would be an excerpt copy. And then I agree with opposing counsel that this is not supposed to be taken as fact, but merely as an expert opinion on what likely happened.
Under those conditions, Exhibit 16 is admitted into evidence not for the purpose of establishing what it purports to show, but it is the evidence, I suppose, of the experts, the witnesses' opinion as to particularly, I think the emphasis is on the route that is depicted on the exhibit.
Thank you, Your
So
Honor.
with that condition, this exhibit is admitted.
Thank you, Your Honor. Detective, let's move on. I understand you are an expert in cell phone technology and forensic data recovery, but CDRs sound a little complicated. Could you please explain, for the sake of the jury, what a CDR is?
Yeah, of course, they do tend to be a little complicated. So when you place a direct, or when you receive or place a direct call or text, a record of that interaction is created, and the record shows the date and time of the communication, whether it was incoming or outgoing, a call or text, and how long it lasted. And additionally, the record also identifies which cell tower that the cell phone was communicating with.
And what does this specific CDR that you created demonstrate to you in your expert opinion?
All right, so this CDR has 3 cell phone towers in a general area with 5 different timestamps. So at 12:47, a cell phone was picked up in the general area of Ms. Becker's house. And then at 12:55, the same cell phone was pinged outside the mall. And finally, between 1:05 and 1:17, the phone pinged 3 separate times, all within close proximity to the victim's house.
Now, this is of vital importance. Detective, did the phone ever ping inside the mall or perhaps, for instance, inside the Fry Shack?
No, sir. And as Exhibit 16 shows, if the phone was ever near the Fry Shack or inside the mall, it would have shown up and been logged on the CDR.
Now, Detective, to reiterate for the jury, does the evidence presented from today's case point to second-degree burglary being committed?
Yes, so after reviewing the case and the evidence, I can see that a perpetrator broke into the victim's house wearing a mask and gloves. And during an ensuing struggle, the victim was stabbed in the back and died as a result, which suggests burglary and, by extension, because of that death, first-degree felony murder.
And Detective, using your expertise, do you believe that it is probable that Miss Becker committed these crimes?
Yes, sir. So the evidence points to the fact that the majority of the communication from Miss Becker's cell phone came from the victim's residence and not the mall, as she suggests. And to me, this shows that Miss Becker was indeed at the scene of the crime.
Thank you, Detective Markowitz. Your Honor, there are no further questions.
Cross-examination?
Yes, Your Honor. Before I begin, could I ask for a brief time check?
Yes.
6 minutes and 14 seconds.
Okay, thank you. All right, then I can begin. Hello, Detective Markowitz. Let's talk about your conclusion of a scuffle at the crime scene. At the crime scene, you noticed drops of blood on the floor, correct?
That is correct.
And you took photos of a blood splatter with a digital camera?
Yes, as is normal when you start an investigation, especially one that involves blood.
All right, but those files were corrupted, weren't they?
Yeah, this is also not really unique to this case. It happens as you go through the process. It's just something that you have to go and take. However, I did review these and I can testify to them. So if that's what you would like me to do, I have the ability to do so.
So you're saying that you frequently corrupt files and lose them so that they cannot be accessed by the jury. Is that correct?
No, that is not correct. So what I'm saying,
Your Honor, the question is argumentative.
May I respond, Your Honor?
You may.
I was simply asking this witness to clarify something she said. She said that files being corrupted is something that frequently happens, and I wanted to clarify whether that was true.
Objection is overruled. This is fair cross-examination.
Thank you, Your Honor.
Okay.
Please proceed.
You weren't able to recover the files, correct?
Would you like me to answer your previous question? It seems to be important.
The question was, you said a few minutes ago that you frequently corrupt files, that is a standard practice. Is that correct?
So what I stated there, especially using a digital camera, because the Denver Police Department doesn't have enough funding to get one of those Canon cameras. It's common practice when you go through the 5 different steps in getting a photograph taken and then analyzed and then a physical copy. It is honestly common and not unique to this individual investigation that a single file became corrupted.
All right. You also claim to notice that Brackman's house was in disarray, correct?
That is correct.
And you could not tell if that was the normal state of the house, correct?
The broken glass and the scuff marks did indicate a struggle, and those do not seem unique to this. Those do seem unique to this situation.
You've never been to Brackman's house prior to the incident, though, right?
No, I believe that would be weird.
So you would not know if there were scuff marks on the floor prior to the murder.
Having 6 scuff marks in very close proximity to one another by a chair that has been turned over does indicate a struggle and is unique to this case in this investigation.
The question was just that you would not know if they had been there prior. And so the answer is no, correct?
Can I answer the question?
Yeah, I asked you.
Having 6 close scuff marks in close proximity is not normal for something to happen within a longer time span.
Okay. Let the record reflect that I'm sharing my screen of what has previously been marked as Exhibit 9. Do you recognize Exhibit 9?
Yes, it is. That is a picture of a broken plate, which once again indicates a struggle.
Okay. And is it a fair and accurate representation of the crime scene?
Yes, a part of the crime scene, as there was also several other photographs that go into the crime scene.
All right. In your investigation, you said you noticed a chair was knocked over, correct?
That is correct.
And there's not a chair knocked over in this picture?
That picture only shows a very small part of the living room. And as I was also previously stated, having a single photograph testifying to doesn't really prove, or it doesn't really show the entire investigation, nor the entire state of the house.
So you also see a pair of scissors in that picture, correct?
Yes, I do. And I also see a magazine and a napkin and a red placeholder.
Okay. I don't need to
and something in the center of the table.
Okay. Did you take the presence of the scissors into account during your investigation?
No, because they were not covered in blood like the knife was.
Okay. Your Honor, at this time, the defense moves to admit Exhibit 9 into evidence.
Response?
There are no objections, Your Honor.
Exhibit 9 will be admitted into evidence for all purposes.
All right. While you were also at the scene, you noticed that several expensive items in Brackman's house were left undisturbed, correct?
Yes, I can assume and infer as my expertise that when a murder happened, the perpetrator was also seen running out. So having killed someone probably put a lot of stress on the situation.
Okay. So let's talk about your investigation and how you led to conclude that Avery Becker was a suspect. So you spoke with another student named Alex Fuentes, correct?
I'm sorry, I'm gonna turn up my volume a little bit. I'm having trouble hearing you. Could you repeat that question one more time?
You spoke to Alex Fuentes, correct?
Yes, because the evidence showed the mock trial team was an important part of Brockman's life. And so therefore I took upon
Okay, hold it. Counsel, please allow the witness to answer a question after you ask it. And Ms. Bell, please try to answer the question as briefly as possible on cross-examination. Yes or no, if that's possible. And if you wish to elaborate, counsel for the, your counsel will be able to ask you to elaborate if he thinks that's appropriate. So please just try to answer the question.
All right, thank you, Your Honor.
Would you like me to repeat the question?
Please proceed.
All right.
Yes, that would be wonderful.
Okay. You spoke with Alex Fuentes, right?
Yes, that's where the evidence pointed me to.
And Alex Fuentes happened to be the first student that you called, correct?
Yes, however, I did also interview other mock trial teams, as was indicated on the Exhibit 17.
Okay. And he sent you screenshots of a text conversation between himself and Becker, correct?
That is correct.
And you never saw the phone, right?
No, so soon after the text messages were sent, Alex did turn in to get a new phone because her battery and all that stuff.
And you have access to Celebrate System, so you would have been able to download the contents of the phone. However, you did not do this, right?
So having the Celebrate System mostly pretends to photo and stuff stuck in iCloud rather than, cell phone text, especially if the text had also been deleted or a phone was replaced and restarted with a new battery.
Okay. But just to be clear, your only evidence of this is screenshots sent by Alex Fuentes, correct?
Yes.
All right. So now let's discuss your analysis of the cell towers. You claim to be able to track Becker's location at the time of the crime using cell towers, correct?
Yes. So as I stated earlier with the CVR, I can place accurately where she was.
Okay. But if you're in a busy area, cell phones can connect to other towers that are not in close proximity, correct?
Although that does stand true in some aspects, something that is important to note here is that a cell phone connected to three towers in the same proximity to the victim's house, and that was evidence that I brought into my investigation.
And lastly, you didn't interview Taylor Perkins, who was the alibi of Avery Becker, correct?
No, I wasn't unable to.
And you didn't interview any employees of a fry shack or anybody at the mall, correct?
No, because the only person who could testify to Miss Becker's whereabouts was indeed her best friend, Miss Perkins.
All right. And you also didn't investigate Blair Rowlands, correct?
Blair Rowlands was missing, and we still cannot find where he is today.
Okay. No further questions.
All right. Thank you, counsel.
Any redirect?
A brief one, Your Honor.
Please proceed.
Detective, you were an active homicide detective for the last 13 years, is that correct?
That is correct. And I've been a homicide detective for 7 of them.
In addition to your expertise as that homicide detective, you earned a 3-day certificate in cell phone data recovery, is that correct?
How long the training was doesn't really matter, as I pull years of expertise that have branched off from that initial training.
And you would agree that you've used that certificate for the last 13 years of your work, is that correct?
Oh, absolutely.
And with that long and extensive 13-year career, would you consider yourself a good detective?
I would. I follow all the leads that would bring me to, and in this case, all the leads and evidence pointed to Miss Becker.
And with that being said, Detective Markowitz, do you believe that you've neglected any aspect of this case?
Oh, absolutely not. I followed up on every aspect of this case. I interviewed everyone I could. I followed everywhere where the evidence could have brought me to, which once again pulled Miss Becker as the perpetrator and the defendant today.
Thank you, Detective. Now, I have just a few more questions for you. Did you yourself corrupt the photos of the blood splatters, or were they just corrupted by accident?
Oh, corrupted files are never on purpose. I just want to clarify that for the jury. So also being a homicide detective means I also have other people working the investigation with me, and corrupted files also relies on my other team members. And so it was not me directly who corrupted that file.
Thank you, Detective. Now, just one last question. Does the fact that no expensive items were stolen from the residency impact any aspects of the charges presented today?
Oh, absolutely not. The fact that there was a murder does tend to, and I can pull my other training in homicides into this, does tend to stress out a perpetrator, causing them to flee the scene as was seen in the Ring video.
Thank you, Detective. There are no further questions, Your Honor.
All right, thank you, counsel.
Thank you. Prosecution, do you have any further witnesses?
No, Your Honor. The prosecution rests our case.
Defense, please call your first witness.
Your Honor, defense would like to call Avery Becker to the stand. Good afternoon, Avery. Could you please state and spell your name for the record?
Hello, my name is Avery Becker, Becker.
Now, Avery, I would like to ask you a couple of questions, if that's all right. What school did you attend to during the time of the murder?
I attended Colorado High School.
And what grade were you in?
I was a senior.
Did you join any clubs or after-school activities while you attended Colorado High School?
Yeah, I was a part of the mock trial team mainly.
Did your mock trial team have any championships or anything related to that?
Yeah, we competed in a lot of different tournaments, the regionals, and we were going to compete in state.
And how long have you been on the mock trial team?
I was on the mock trial team for all 4 years of high school.
Did you have any specialty in mock trial, considering the fact that you're on the team for about 4 years?
Yeah, I mean, I think my main specialty was probably crosses and closings. I would say that was definitely what I did the most, and also what I was the best at.
Do you know of anyone who could have disagreed with that statement if someone were to disagree?
Yes, so I mean, I'm not 100% sure, but sometimes.
This question calls for speculation on behalf of the witness.
Response?
This witness has actual personal knowledge to the fact to which she has testified.
Your Honor, if I may, the witness may have firsthand knowledge of this account, but they are still speculating to the words of others.
Overruled.
Thank you, Your Honor.
If I may continue, I know my coach didn't, me and my coach didn't get along particularly well, so they might have disagreed. And also a few teammates, such as my teammate, Alex Sufuentes.
Moving on, could you please state to the jury as to why you are here today?
Yeah, I'm here because I'm being blamed for a murder that I did not commit. And despite a rocky relationship with Coach Brackman, I still want justice for him and his murder. And I'm here to tell my story.
You mentioned Mackenzie Brackman, the victim. How do you know Mr. Brackman?
As I stated, he was my mock trial coach.
And how is your relationship with him?
We didn't get along particularly well. Yeah.
Why didn't you get along?
Well, we both had pretty different styles of kind of working, and he really liked everything to be super prepared, while I was more try to focus on trying to do things and like kind of while they were at the trial, you know. So he liked to have everything pre-written, and I was more like kind of on the spot. And we had kind of a few altercations and arguments.
Do you have any specific examples of a time you had an altercation?
I mean, one of the first ones that I can think of is when I was knocked down to the B team. And yeah.
Did you try and do anything to get back on the team you were on before?
Yeah, actually, my friend Taylor actually quit the team, and then I was able to have my spot back on the A team, coincidentally.
You mentioned your friend Taylor Perkins. Could you please describe your relationship with Taylor?
Yeah, Taylor and I have been friends for all 4 years. She's my best friend. She's really good at kind of the reason I appreciate her. She's really good at kind of keeping me in check. Yeah.
So do you spend a lot of time with Taylor?
Yeah, I mean, I was actually, I spent pretty much like majority of my free time with her. I was actually with her on the day that the murder was committed.
Were you with her the entire day the murder was committed?
Yeah, I was. And yeah, yes.
What were you doing?
We were looking for my phone.
Did you lose your phone?
Yes, I think I lost it, but it also could have been stolen. I'm not sure.
All right. Did you ever find your phone?
No, I still haven't found the phone.
All right. And circling back to Mackenzie Brackman, did you have any specific altercations with Brackman near the time of the murder that were particularly troubling?
Yeah, actually, right before the murder, we had a huge argument right after regionals.
And what were you arguing about?
We were arguing about whether my performance at regionals, which I had won awards for, was kind of good or bad, or whether that was deserved. And he kind of insulted me in front of everyone while we were reviewing our stuff.
And how did you feel about him insulting you?
I felt kind of sad and also embarrassed because it's pretty hard to have an authority figure, you know, no matter how much you get along with them, say those types of things.
So what did you do in response?
So I ran out of the room, and in my hand was a dry erase marker that I had been about to use to write the things on the whiteboard that our team did well and poorly. And I ran out and I saw his car, and in a moment of not thinking, I drew the words "Worst Attorney Award" on his car.
And how did you communicate with your coach, Mackenzie Brackman, regarding this incident?
Well, he basically walked out on me right after, and then he kicked me off the team. And so I went home and I talked to my mom, and we basically kind of discussed. And I thought about it more, and I thought, well, clearly this behavior was inappropriate. And I've definitely learned a lot from that. And what I did is I reached out to him. I tried to go and see him in person, and then I texted him a few times, and he never got the chance to respond.
What were your morals after Mackenzie Brackman had found the damage done to his car?
Well, I mean, obviously, I felt bad about it. And I kind of realized, like, that is something, maybe not kicking me off the team was justified, but I realized kind of the weight of causing property damage.
Next, I'd like to discuss your affiliations with someone involved in this case. Are you familiar with Alex Cifuentes?
Yes, I am.
And how are you familiar with Alex Cifuentes?
Alex is another student on the mock trial team.
What were your feelings towards Cifuentes?
I mean, I didn't get along with her that well. I didn't know her super well. Yeah.
All right. Was Cifuentes on your mock trial team the same amount of time you were?
Yes. We were both on the mock trial team for all 4 years.
All right. During those 4 years in mock trial, how did your relationship with Cifuentes grow or fall?
I wouldn't necessarily say that we really had a relationship, but I guess if you were to put it like that, I would say that it fell, because I think we were pretty close at the beginning, not necessarily close, but friendly to each other. And then we both wanted the same roles, so there was a little bit of conflict and jealousy over that.
How would you reach out to her if you ever needed anything regarding school, mock trial, or a serious situation such as this one?
I really wouldn't. I'm not really sure.
All right. Your Honor, permission to present my screen to which has previously been marked as Exhibit 14.
You may.
Can you see my screen?
Yes.
All right. Do you recall these messages?
I do not recall ever sending these text messages to Alex, no.
All right. And is there anything specifically that you don't recall besides that?
I never knew where Brackman lived.
All right. Lastly, going back, could you please specify as to why you would rather reach out to anyone rather than Alex Cifuentes?
Well, just from my point of view, it seemed that Cifuentes was a little bit of, I don't know, just kind of jealous of my success and slightly, I don't know. I definitely wouldn't trust Cifuentes.
All right. No further questions, Your Honor.
Cross-examination?
Yes, Your Honor. Good afternoon, Ms. Becker. My name is Liam Slavin. I will be conducting your cross today. Please limit your questions to the shortest possible length. Thank you. Now, were you at school on the day of March 6th, 2020?
No, I was at the mall.
Where were you? You were at the mall. Okay. So you were saying that you ditched your classes on the day of the murder of Mr. Brackman?
I didn't feel that we needed to go to the classes today, no. And yes, I didn't.
Did you alert anyone to your whereabouts on the day of March 6th?
I do not believe I alerted anyone aside from my best friend, Taylor.
So you only have one person to testify to your whereabouts on the day of March 6th?
Unless the employees at the mall or the Fry Shack have been brought to court, then no.
And just to confirm again, that person is Taylor Perkins, correct?
Yes.
Now, Ms. Becker, is Ms. Perkins your best friend?
Yes, I would say that.
So let me get this straight for the sake of the jury. The only person who can vouch for your whereabouts on the day that the victim of this case was murdered is your best friend. Is that correct?
She was the only one that was interviewed.
Thank you, Ms. Becker. Let's move on. Now, earlier you stated that you were searching for your phone and that you believe Mr. Cifuentes stole it. Is that correct?
Yes, I do think that Mr. Cifuentes may have played a role.
And you claim that Alex falsified text messages that you sent him.
Yes, I'd never sent those text messages.
And Ms. Becker, on line 142 of your witness statement, do you say, quote, and I have no idea what those text messages might have said because I never sent them?
Yes, but I did see the exhibit presented today in court.
But Ms. Becker, you believe that Mr. Cifuentes was using these text messages to frame you for trashing Mr. Brackman's house. Is that correct?
I wouldn't say that I'm necessarily qualified, but that is my theory, yes.
So you do say on line 140 to 141 of your witness statement, quote, they plan to use it to make it look like I trashed Mr. Brackman's house?
That would be my guess, yes, actually.
So Ms. Becker, how exactly do you know what was sent on those text messages, as you stated in your witness statement, considering you claim to have lost your phone and never seen them since you never sent them?
Well, I just guessed that if they were going to be used in court, then they were incriminating in some type of way. I am on the mock trial team. I do have basic logic.
Let's move on. Would you agree that you and Mr. Brackman did not get along very well?
Yes, I would.
Did you call Mr. Brackman, quote, the worst attorney in the state?
I did.
Did you call him, quote, a lousy attorney?
I did.
And did you, in a fit of anger, vandalize Mr. Brackman's vehicle with the words, quote, worst attorney award?
You might not describe it as a fit, but it was, sure, yes.
And Ms. Becker, did you or did you not say in your witness statement, quote, that I would get back at him if it was the last thing I did?
I didn't. So to clarify a little bit, I put
Becker,
in my witness.
yes or no question.
No,
did you or did you not say those words?
This question. So I did not write those words in my witness statement. I have said those words, but I did not write them in the witness statement. I said those words.
Do I have permission to share my screen?
Can I?
Counsel and Ms. Williams, don't speak over each other, please. Counsel, allow the witness to answer your questions. And
my apologies, Your Honor. Please continue, Ms. Becker.
Ms. Williams, I will ask you, please listen to the question and answer it as briefly as possible. This is cross-examination.
All right. I was just particularly saying that I did say those words, and I wrote that I said those words in my witness statement. Yes, but the question was slightly misleading. I apologize.
Thank you, Ms. Becker.
Okay, please proceed.
There are no further questions, Your Honor. The witness answered the statement.
Any redirect?
No redirect, Your Honor.
Okay. Thank you. Defense, please call your next witness.
Defense would like to call Taylor Perkins to the stand. Ms. Perkins, could you please introduce yourself and spell your name for the record?
You're on mute.
Sorry, my computer was not working for a second. Yes, my name is Taylor Perkins. Perkins spelled Perkins, and I'm a student at CU, and I attended Colorado High School with Avery Becker.
Could you please explain your relationship with Avery?
Yeah, she was my best friend in high school. We went to school together, and we were also on the mock trial team together.
What was Avery like when you interacted with her?
She was very outspoken and passionate, and like I said before, she was my best friend, so we told each other everything.
So crushes, drama, any issues you were having with each other, you told each other that?
Yes, everything.
Okay. So I think you mentioned mock trial. What was that like for you?
I mostly just joined it because Avery was doing it. It was fun, but it was not really my thing. Everyone was just super competitive.
And what was your relationship with Mackenzie Brackman?
He was my mock trial coach, and that's pretty much all. I heard about him a lot because of Avery, because they didn't have, I guess, the best relationship, but we really didn't have much of a relationship.
And so, were there any times that you witnessed tension between Avery and Coach Brackman?
A little bit. I mean, Avery was sometimes late to practices, and she sometimes messed around and everything, but he was always mostly mad at her for just being naturally good. Every time that she like won an award or a medal or won a competition, he would get mad at her because she was just naturally good without even trying.
And when did the tensions start to occur between Avery and Coach Brackman?
I don't know, like I just said, just every time that she won something or did well or just messed around.
Were you close with the other members of the mock trial team?
I mean, yeah, we talked a little bit and we were in contact, and we sometimes met at and got lunch after practice or something.
Okay. Were you there the night that Avery was demoted?
No, I was not there.
And how did Avery react to that?
Well, I heard from my teammates that she was really angry.
Objection, Your Honor. Hearsay.
Hans?
I will move on. So how did you react after Avery was demoted?
I felt really bad for her because I didn't think she deserved to be demoted. And so I gave up my spot because, like I said before, mock trial really didn't mean a lot to me, and it meant a lot more to her. So I was fine giving up my spot for her.
Okay. Were you in contact with Avery the night that Coach Brackman's car was vandalized?
I wasn't there physically, but I heard from her after what happened. And I know that she completely didn't mean to do it. And she was so unbelievably like
Objection, Your Honor.
sad.
Hearsay.
May I respond, Your Honor?
You may.
I'm going to rephrase the question. Ms.
Thank you,
Perkins.
counsel.
Ms. Perkins, after Avery vandalized the car, how did you observe her as acting?
I observed her as acting very remorseful. She felt really bad about doing this thing. She didn't mean to do it at all. And she was just overall really upset that she did it in the first place, and she didn't mean to do it.
Did you help Avery try to get back on the team?
Yeah, I mean, we talked about ways for her to get back on, including like texting everyone on the team.
Okay. What was your relationship with another team member, Alex Cifuentes?
I didn't really have much of a relationship with him. I know that Alex Cifuentes and Avery didn't really get along that well, but I didn't really have anything to do with him.
And so, in your observations, what was Alex's relationship with Avery?
I mean, they were always really competitive. Alex was always jealous, I would say, of Avery because Avery always won everything and she always got the good roles.
Hearsay.
Response?
Yes, Your Honor. I'm asking my witness to testify to her observations between Avery and Alex, not what they said to each other or what they did to each other, just what she saw.
Response, Your Honor.
You may.
I was objecting because the witness was testifying to Alex's feelings towards Avery, which she cannot testify towards.
I'm going to sustain the objection and just caution the witness and counsel. Please try to limit your testimony to what you've personally observed.
Thank you, Your Honor.
What you've seen and so on, as opposed to at least initially how somebody felt or what they thought and so on.
Okay, Your Honor.
Okay.
Thank you. Did you observe so since you were Avery's best friend, Would you say that Alex had a similar relationship to Avery as your relationship to Avery and what you observed?
No, I would say that I observed Alex and Avery having a little bit of tension while I didn't have really any tension with Alex.
Okay. So the night before the murder, where were you?
I was with Avery.
Okay. And where were you with Avery that night?
Avery swung by my house and we hung out and played games. And then later we went to grab something at Fry Shack.
And what happened at the Fry Shack?
We ran into the rest of our mock trial team and everybody was talking to Avery about how it was so unfair that coach kicked her off. And even Alex Cifuentes said something.
Oh, so how was Alex acting that night from what you personally observed?
I personally observed him being kind of passive aggressive in a way. It was almost like he was still insecure and kind of happy that she got kicked off.
When you left, did Avery have her phone with her?
I don't believe so. I don't totally remember, but I think she might have left it on the table.
Okay. So when did you notice the phone was missing?
When Avery picked me up from my house the next day.
And what did you do that morning once you noticed the phone was missing?
We ended up ditching school and spent the day retracing our steps, trying to find Avery's phone.
Okay. Where did you go to try and find Avery's phone?
We first went to the mall and checked all the stores that it could have been in. And then when we didn't find it, like I said before, I remembered it maybe being left on the table at Fry Shack. So we headed back there and we also couldn't find it there. And during that whole time, we used my phone to call Avery's phone multiple times, trying to find it.
Do you know if there are any security cameras where you went that day?
There probably was, but I really didn't notice any or was checking for them.
Okay. Were there any other places that you and Avery went that day?
After we just continued to drive around, calling her phone and stuff.
Okay. Were you and Avery together the entire time that day?
Yes, the entire time.
And were you with your phone the entire time that day?
Yes, that's what we used to text Avery's phone and call Avery's phone.
Did any detective reach out to ask where you or Avery were that day?
Avery's lawyers called us, or called me at least, and asked about me being a witness, but no detective.
Did they at least email you or text you to ask if you wanted to interview with them?
No.
Okay. So when did you hear that Coach Brackman had been killed?
Later that day.
Okay. Were you with Avery at that time?
Yes.
And how did you feel once you heard that Coach Brackman had been murdered?
I was shocked. I would never think something like that would happen to me. And I was overall really sad. I mean, he was still a good coach. I mean, even after everything that went down, I mean, nobody deserves to die.
Last question. Would you lie about this or anything else that's serious to save Avery or any friend?
No, of course not. I mean, Avery was my best friend, and of course we told each other everything. But when it comes to life and death, no, I would never lie for her, and I would never lie for anyone. I mean, this is someone's life that we're talking about.
Okay, no further questions, Your Honor.
Cross-examination?
Yes, Your Honor. May I proceed?
You may.
Okay. Hello, Mrs. Perkins. My name is Kyle Branson, and I'll be conducting your cross-examination today. Let's first talk about your and Avery's relationship with Coach Brackman. So would you say that both you and Avery dislike Coach Brackman as a coach?
May you repeat that? Sorry.
Would you say that both you and Avery disliked Coach Brackman as a mock trial coach?
I would say that I think it was pretty clear that Avery and his relationship was obviously not the best, but I wouldn't necessarily say that I completely disliked him. I didn't like how he was always yelling at Avery, but I wouldn't say I disliked him.
Okay. Are you aware that you said in your witness statement, quote, "I thought Brackman was a mediocre coach and an even more mediocre lawyer"?
Yes.
Okay. So just to reiterate, you and Avery both had at least little respect for your coach, correct?
I mean, yeah, I mean, he didn't treat Avery super well, but again, he was my coach. I still respected him still.
And going off of that, Avery didn't treat Coach Brackman well either, correct?
I mean, yeah, she was late to practices and was messing around, but the only time that she really felt anger towards him was when he was being mean to her.
Okay, but this made Coach Brackman extremely upset, correct?
Yes, I think he didn't have a lot of respect for her being naturally good when she messed around.
Okay, and that led Avery to purposely instigate conflict on multiple occasions, correct?
Well, if you're referring to the vandalism of his car, that was not purposeful. She only meant to get out some anger, and she didn't think it was permanent.
Okay, but did she intend to write on Mr. Brackman's car, quote, "worst attorney award"?
Yes, with the dry erase marker though.
Okay. So you could say that she purposely instigated conflict, correct?
I would say that he instigated it first, and her messing around wasn't her instigating conflict at first.
Okay. One last question regarding that. Is it fair to say that Avery could sometimes be rash?
Yes, I mean, she's a teenager sometimes, but nothing out of the ordinary.
Okay. Now let's move on to your relationship with the defendant, please. You and Avery were best friends, correct?
Yes.
Okay, so did you heavily value that relationship?
Yes, of course. She was my best friend.
Okay, and you also joined and later left the mock trial team because of Avery?
Yeah, like I said, it didn't really mean a lot to me, and I joined it purposely for Avery.
Okay. But could we conclude that you would go to great lengths for your best friend, the defendant?
Yes, and for a certain extent, yes.
Okay, and now let's move on to the events preceding the murder of Coach Brackman. Is that okay with you?
Yes.
Okay, so according to your report, Avery came to mock trial extremely unprepared and making Coach Brackman mad again, correct?
Yes.
Okay, and after Avery's poor preparation, she was subsequently kicked off the team?
Yes, she was.
Okay, and after Avery was kicked off the team, then that also caused you to leave the team as well?
Yes, I mean, I didn't want to do it without Avery.
Okay, but that subsequently forced Mr. Brackman to take her back?
Yes, I did it so she would be able to get onto the A team again.
Okay, and then they did very well at the regional tournament, but afterwards they got into another conflict, correct?
Yes.
Okay, and afterwards, again, as we referred to earlier, Avery defaced the hood of Mr. Brackman's Porsche 911.
Yes, again, like I said, she didn't completely mean for it to be permanent.
Okay, and consequently, Avery was kicked off the team again, correct?
Yes, she was.
Okay, and COVID canceled the state tournament, and afterwards, she planned to apologize, but she approached Coach Brackman after practice, but she was told to leave, correct?
Yes, she was.
Okay, and afterwards, you guys went to the afterwards, you and Avery went to the Fry Shack.
Yes, we did.
Okay, and at the Fry Shack, Avery got extremely flustered and stormed off again, correct?
Yes, she did. Yeah, and then I think she might have left her phone on the table.
Okay. You believe it was extremely weird for Avery to leave anywhere without her phone?
When she was not flustered, but like you just said, she was very angry and disorganized and kind of just confused on what was going on.
Okay. That will be all for today, Your Honor.
Thank you.
Thank you.
Any redirect?
No, Your Honor.
All right. Thank you. Defense, please call your next witness.
The defense calls Professor Blake Van Owen to the stand. Please state your name and spell your last name for the record.
Yes, Blake Van Owen, Vanowen.
Good afternoon, Professor Van Owen. Let's begin by talking about your experience in law enforcement. How did you begin your career?
I joined the Aurora Police Department in 2005.
How long were you in the police force?
I worked for the police department for 9 months between 2005 and 2006.
And why did you leave the police force?
Unfortunately, I was involved in an incident in which I injured a young woman of color during her arrest. I was officially cleared of wrongdoing, and the technique I used to arrest her was approved. However, I have never cleared myself fully of wrongdoing. Again, I wish I had known then what I know now. The incident made me realize that I disagreed with a lot of police practices, so I left the force in favor of a career that focused on checking police power.
When did this incident occur?
In 2006, over 15 years ago.
What did you do for a living after leaving the force?
After leaving the force, I worked as a school resource officer, a private security guard, and then went into private investigation. Since 2015, I've also started teaching a class on police procedures at the Community College of the Rockies. I obtained a master's degree in criminal justice, and I have taught a course at CU Denver in police practices and social justice.
Have you ever testified as an expert witness in court?
Yes, I've testified as an expert in 25 cases, including crime scene reconstruction 8 times, cell tower analysis 5 times, and in general police investigation tactics 12 times. I've also consulted on over 100 cases and have been accepted as a defense expert in the U.S. District Courts for the districts of Colorado, Kansas, and Arizona, and in the state courts of Colorado, Wyoming, Nebraska, and New Mexico.
Which areas have you testified as an expert in?
I avail myself as an expert in the use of police practices, the use of force, false arrests, forensic evidence, crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Your Honor, the defense moves to enter Professor Blake Van Owen as an expert in crime scene reconstruction, police investigation tactics, cell tower analysis, and forensic evidence.
Okay, let's go through those. Police practices, crime scene reconstruction. Next.
Cell tower analysis and forensic evidence.
Cell phone analysis and forensic
evidence.
Okay. Any objection?
Yes, a brief voir dire. Good afternoon, Professor. My name is Mackenzie Dana, and I will be conducting your cross as well as your voir dire at this time. Do you agree that police department procedures are constantly changing from year to year?
To some extent, yes. However, as I have obtained a master's degree in criminal justice, I know the up-to-date police procedures.
But you would agree that they do change from year to year?
To some extent, yes, but the overall uses that the police force uses don't really change.
But you even admit that the police procedures have changed specifically since the incident and when you were in the force, correct?
To some extent. However, I stay up to date with the current police, again, as I have taught many courses since then, and since then, obviously, obtained a master's degree in criminal justice.
Thank you. But it is also true then that you have not been in the police department for many years?
Yes.
And yet you still claim that you can testify as an expert in these changing police procedures?
Yes. Again, as I said, I have taught 2 courses and obtained a master's degree in criminal justice, and I've continued to testify in these areas. 12 times specifically for police investigation tactics.
The prosecution objects to Professor Van Owen being admitted as an expert in police practices and procedures because it is beyond her area of expertise, since she has not been intimately involved with them for many years. Thank you.
Response?
Yes, Your Honor. So first of all, Professor Blake Van Owen does have a master's degree in this field. She also did work as a police officer, and she keeps up to date with all the necessary protocols because it's her job to review such protocols.
Reply?
No reply, Your Honor.
All right, the objection is overruled, and this witness is deemed qualified as an expert in the fields mentioned and may testify through opinion evidence as an expert under Rule 702. Please proceed.
Are you aware of Kuzak's conclusions in today's case?
Yes, and I agree that the evidence points to an intruder who broke into Mr. Brackman's home. However, I take issue with Kuzak's narrative of how this crime occurred.
What are Kuzak's conclusions?
Well, Kuzak appends, without support, that upon entering Brackman's home, the intruder was surprised by Brackman and stabbed Brackman after gaining control of a knife that Brackman obtained from his knife block. I take issue with this assumption of a struggle.
And why do you take issue with that specifically?
There's no evidence of a struggle. The only evidence is supposed scuffing on the floor, but we don't know when these marks were made. Those marks could have been on the floor before the incident. Markowitz and Kuzak simply cut a corner and assumed that they were there as a result of the struggle, again, with no evidence.
Are you aware of Kuzak's investigation of the murder weapon?
Yes, Kuzak also assumes that the murder weapon came from Brackman's kitchen, but acknowledges that it's a completely different brand.
And why do you take issue with that conclusion?
The murder weapon was completely inconsistent with the style and dimensions of all the other knives, as I said. So this leads me to believe that the knife didn't come from the victim's kitchen, but was instead taken to the crime scene by the perpetrator. Kuzak just made the most simplistic assumption without taking the evidence into account.
Why is the situation leading up to Mr. Brackman being killed significant for this case?
What's significant because this means the intruder would have been expecting Brackman, because the intruder broke into Brackman's home with the intent of killing him.
Are you aware of any other evidence Markowitz discovered at the crime scene?
Yes, Markowitz also claims to have seen blood spatters at the crime scene. However, they managed to lose all pictures of the spatter in the hallway and the apparent cast-off on the wall near the front door. The file containing this amazing evidence was mysteriously corrupted, which I find is an indicator of the utter incompetence in this investigation.
Did you analyze Detective Markowitz's cell tower analysis?
Yes, Markowitz attempts to claim that Avery's cell phone was near Brackman's house at the time of the murder, based on cell records. However, that is far from saying that Avery was near the house.
And why do you take issue with Markowitz's conclusion about that?
There is overwhelming evidence that Avery lost her phone the day before the murder, which was confirmed by Taylor Perkins, again, for their corroborating Avery's alibi. Even so, cell tower information is nowhere near an indicator of location.
So why can't cell tower information be used to indicate location?
Well, cell tower data isn't remotely similar to GPS information. Cell phones are able to communicate across large areas, even up to 100 square miles. Also, cell phones can connect to farther towers if the nearest towers are busy. It isn't unusual for a single phone to get 5 calls and connect to 5 different towers.
Are you aware of any other cell phone records that were investigated?
No, Markowitz only investigated Avery's cell phone records. Yet another corner cut. Markowitz did not look at Taylor Perkins' cell tower information or anyone else's in the area. It just shows that Markowitz already had his mind made up.
What did the investigation reveal about Avery's location?
Well, as you can see in exhibits 15 and 16, the records show that for each of the calls and texts involving Avery's phone, there was a corresponding caller text from Taylor's phone. Antenna 2 also covers them all, so the records are entirely consistent with Becker and Perkins calling and texting Becker's phone to try to find it as they retrace their steps. Antenna 3 also covers the fry shack, again, aligning with Avery's alibi.
Are you aware of the screenshots used in the investigation?
Yes, the police simply accepted screenshots of the messages, but never actually investigated the contents of the actual phone. They have the tools to do so, including a forensic software called Celebrite that Markowitz claims to be an expert on themselves, and even used earlier in this investigation.
All right, did your investigation lead to any other suspects?
Yeah, after thoroughly investigating, I investigated Blair Rollins, which is another student at CHS.
Why did you investigate Blair Rollins?
Well, Blair Rollins had a strong and clear motive to kill Mr. Brackman. Brackman represented Blair's father, Jonathan Rollins, in court. Jonathan ended up being sentenced to life in prison. I discovered a recording from the trial that resulted in Jonathan's conviction that points to a strong motive.
How would you describe Jonathan Rollins' demeanor in the recording?
It's chilling. Jonathan is clearly extremely angry.
I am now showing the witness what has previously been marked as Exhibit 22. Do you recognize this?
Yes, I do.
How do you recognize Exhibit 22?
It's a copy of the recording I obtained of Jonathan Rollins after Jonathan heard his sentence in court.
Is it a fair and accurate representation of that?
Yes, it is.
Your Honor, at this time, may I play the recording?
You may.
I'll get you back, Brackman, if it's the last thing I do.
Your Honor, at this time, the prosecution or the defense moves to admit Exhibit 22 into evidence.
Response?
Yes, two objections, Your Honor. First, this is hearsay because it is an out-of-court document. Second, relevancy. This video is of Blair Rollins' dad, not him, so we cannot testify to whether Blair Rollins' dad speaks for Blair Rollins.
May I respond, Your Honor?
You may.
This is an exception to hearsay because this is an excited utterance, and that is Rule 803.2. And this statement was made by Jonathan Rollins while he was under the stress of receiving his sentence. Additionally, this is relevant because Jonathan Rollins obviously has a close relationship to Blair Rollins.
Reply?
My former reply still stands, Your Honor.
The objection is overruled and Exhibit 22 is admitted into evidence for all purposes.
How does Blair Rollins relate to this?
Well, yes, as a response, Blair was present at the trial and spoke on Jonathan's behalf at one point in the trial.
Would Blair have had the opportunity to commit this crime?
Yes, Blair also went to CHS and was a senior last year. Blair has the same build and body shape as Avery, and she essentially disappeared after the graduation. She was also absent from school on the day of the murder. Also, as aforementioned, Blair was friends with Alex Cifuentes. Given that Markowitz blindly accepted the Cifuentes screenshots, it's very possible that Cifuentes took Avery's phone and gave it to Blair to implicate her. After all, Rollins and Cifuentes were friends. It's also possible that Blair simply found Avery's phone and used it to implicate her. Not investigating this clear suspect is a great example of the messy and incomplete investigation performed by the prosecution.
No further questions, Your Honor.
Are you ready, Your Honor?
Cross-examination?
All right, I will begin. Good afternoon once again, Professor Van Owen. Let's begin your cross. You've been called today to the stand to represent the defense. Is that correct?
Yes, correct.
Are you being paid for this?
Yes, I am, as a private investigator, along with Markowitz and Cusack.
How much are you being paid?
I have made 7,000.
Relevance.
Oh.
This is laying foundation for further questioning.
Overruled.
What are the three things that you were actually paid to do?
So I am paid as a private investigator by the defense, as I was hired by the defense. So I am being paid to investigate and then appear in court.
So you are being paid by the defense to prove Miss Becker's innocence?
Yes, I'm paid to conduct a thorough investigation and then use my findings to testify in court, as I said before.
With the aim of proving her innocence, is that correct?
The defense has the burden of proving beyond a reasonable doubt that Avery Becker did not commit this crime.
Thank you. Let's talk about the knife then. You would agree that the knife exhibit number 5 is not the same style as the other knives in the block?
The knife, yes, the knife shown is not the same as the knives in the block.
But there was a missing spot in the knife block?
Yes, however, the knife was never measured and neither was the hole in the block. Markowitz claimed to say that it could fit. However, he provided no real evidence as if it could actually fit or was measured to fit in that slot. So
I will ask you at this moment to please try to limit your answers to the shortest possible length, and I will move on with my next question. Is it possible that the knife from that spot was broken or lost?
It's possible that a knife was lost. However, this has no relevance to the case.
Is it possible then that the knife may have replaced a broken knife spot in that block?
Again, we can't know that this knife would even fit or was even the same dimensions as the slot in this knife block because it was never measured. So no, we cannot assume that this knife could have been replaced.
But a large chef's knife was missing from that very spot, correct?
Again, the words large have no real meaning. Again, because this knife was not measured. Unless you have a measurement to provide for me, I cannot tell you no that it would fit in that slot.
But it was a large knife spot, a large or a chef's knife of some sort that was missing.
There was a knife that was, yes, I would assume that a knife would go into a knife block. However, again, there was no measurements, and so we cannot assume that the knife that is being used as part of this case was from that knife block.
Will you remind me what type of knife was found at the scene of the crime?
The knife found at the scene of the crime was again, just a knife, but it did not match the knife in the knife block.
But you would it was a large chef's knife?
Objection, Your Honor. Asked and answered.
I'm sorry, what's your objection?
Asked and answered.
Response?
I'm actually asking specifically about what type of knife was found at the scene of the crime, not in the knife block. So this question has not been previously asked or answered.
Overruled.
I will ask that again to refresh your memory, Professor. What would you agree that the type of knife found at the scene of the crime was a large chef's knife?
Again, I'm no expert in different types of knives. However, yes, I guess it was a fairly large knife. But again, large in this sense has no real meaning as there was no measurements provided by Markowitz.
Let's look more into the Ring videos. You assume that the Ring video notifications did not alert the victim, and so he did not go to investigate, thus diminishing the likelihood of a struggle. Is that correct?
Yes, it's very fair to assume this. The notifications could have been turned off or simply ignored or simply not heard. If you're listening to a music or a podcast or on a Zoom meeting, it's very easy to miss a single notification.
A simple yes and no will suffice for most of these questions, and I will move on. And your own reconstruction of the crime scene rests on the idea that Mr. Brackman was not alerted, correct?
Correct. And again, as I said before, this is entirely possible and likely more probable.
But in Exhibit 12, there is a noise from the sliding door and the nearby streets. Is that correct?
Again, as I said before, this noise may not have alerted Brackman.
But there was noise, correct?
Yes, there was a fairly quiet noise, but again, this is, I don't see the relevance to this in this certain case.
However, based on your previous answers, we can all be drawn to the conclusion that it is very possible that Brackman was notified, even if not by the Ring notifications or by the sliding of the door and the street noise.
There was a quiet noise. However, again, like I said, if you're listening to a music or in a Zoom meeting, for example, it's very easy to miss certain quiet noises that are coming from the other side of your house. So no, it's not fair to assume this.
Let's move on. Now, you were admitted as an expert. What exactly were you admitted as?
So as I have testified before, again, in over 25 cases, I am an expert in crime scene reconstruction, cell tower analysis, general police investigation tactics, and I've consulted on other cases regarding the use of force, false arrests, forensic evidence, crime scene reconstruction, cell tower analysis, and general police investigation tactics.
Thank you. So you are not an expert in cell phones, cell phone data, data recovery, or forensic data analysis. Is that correct?
Like I said, I am an expert in cell tower analysis.
I don't need a repeat. I just need a yes or no for this question.
Can you restate the question?
Of course. You are not an expert in cell phones, cell phone data, data recovery, or forensic data analysis.
Cell phone data in the sense of cell tower analysis, yes.
Okay, but you would agree that you're not qualified to speak about these all very important and different aspects of cell phone technology.
I am an expert also in forensic evidence, and I believe that some of this falls under forensic evidence as it is general evidence in this case.
Well, let's look at something that specifically falls under your field of expertise, which would be the cell tower records. So you would agree that Detective Markowitz only investigating the records for a period of time before the murder is irresponsible.
But before the murder, I'm sorry, can you restate the question?
Yeah, of course. You would agree that Detective Markowitz only investigating the cell tower analysis records for the period of time before the murder is irresponsible, correct?
Yes, clearly, because more leads could have come from looking more into the cell tower data in the whole area and of other people nearby, or looking into, for example, Perkins's phone, which would further corroborate Avery's alibi.
Once again, I'll remind you that for most of these questions, a yes or no will suffice. And if I need you to elaborate, I will ask you. Wouldn't you agree that this is because the phone lost connection to the cell towers because it was turned off?
Yes, it's likely.
So there was no actual way for Detective Markowitz to investigate further.
Do you mean after or before the crime?
After the crime, other periods of time which he did not, or which she did not actually investigate.
After the crime, yes. The term other periods of time, I'm not exactly sure what you mean. For example, during and before the crime, but I would agree that after the crime, yes.
Okay, there are no further questions, Your Honor. Thank you, Professor.
Any redirect?
No, Your Honor.
All right, thank you. Does the defense have any further witnesses?
No, Your Honor. At this time, the defense rests.
Okay. Are counsel ready to proceed with closing arguments?
Yes, Your Honor. And I request that I be allowed to reserve time for a rebuttal.
You may.
Thank you, Your Honor. Then I will begin. Your Honor, ladies and gentlemen of the jury, we are gathered here to seek justice. This quest for justice, as well as our whole legal system, was built by the great Greek philosophers of old. In light of this, let us turn to our Greek ancestors. Let us return to the roots of both justice and truth and turn to our Greek ancestors. In 441 BC, Sophocles wrote the play Antigone. Within this, we see the destructive seeds of pride grow into the wicked vines of murder. Much can be learned about murder, pride, and human nature, but the connection between pride and death is a clear one. A connection that spans thousands of years from 441 BC to 2020 AD. As you've seen throughout this trial, Avery Becker stands accused of murder, a murder that was born out of pride. Unfortunately, a literary connection is not enough to convict Ms. Becker. We, the prosecution, accepted the burden of proof and will lay out the facts of this case to prove beyond a reasonable doubt the guilt of Avery Becker. Today's case rests upon 3 charges: first-degree murder, second-degree burglary, and criminal mischief. The testimonies of Detective Markowitz, Alex Cifuentes, and Taylor Perkins all point to Ms. Becker having committed criminal mischief against Mackenzie Brackman. After all, in the words of Ms. Perkins, quote, Avery needed to get some anger out against Mr. Brackman. And oh, was there some anger against Mr. Brackman. Her history of brash violence and mock trial pride led her to commit this act. The cross-examination of Avery Becker shows that she harbored criminal mischief and hate towards Mr. Brackman. And in her own words, let us remember that she said, I would get back at Mr. Brackman if it was the last thing I did. Now, if Ms. Becker committed criminal mischief against Mr. Brackman while also breaking unlawfully into his residency, then she committed second-degree burglary. This evidence and testimony provided by Detective Markowitz and Kyle Kuzak clearly show that Ms. Becker broke, entered, and remained unlawfully while also committing criminal mischief. The ring video entered by the detective in combination with these testimonies points to this fact. Therefore, Avery Becker committed second-degree burglary. Now, it is the known fact that Mackenzie Brackman died on March 6th after someone broke into his residency. And since Ms. Becker is guilty of the previous 2 charges and the victim died while she was committing these crimes, then she is guilty of first-degree murder. Now, in accordance with the jury instructions, we, the prosecution, have fulfilled our burden of proof. Therefore, good gentlemen and ladies of the jury, Avery Becker is guilty of criminal mischief, second-degree burglary, and first-degree murder. Thank you.
Defense, your closing argument, please.
Yes, Your Honor. I will begin that now. This trial right now is not about justice. It's not about Greek philosophy. It's a sham put up by an incompetent investigation. I do not care about mythology. I care about evidence, and I care about the lack thereof. And the prosecution has demonstrated in today's trial that their theory of the case is nothing but mythology. They lack all the evidence that they would need in order to prove that Avery is guilty beyond a reasonable doubt. They have not met this burden. So, Your Honor and members of the jury, please allow me to address you on behalf of Avery Becker one final time. The prosecution's theory of this case may have started as a square, but it has cut so many corners that it's now a circle. Overall, despite butting heads, my client, Avery Becker, has testified that she had a positive relationship with Mackenzie Brackman, one that she was invested in preserving. After making the mistake of marking Brackman's car, Avery was intent on apologizing and making amends, even offering to get a summer job to pay for the new paint. She may not have been the perfect student, but Avery loved being on the mock trial team and wanted more than anything to be reinstated. Grabbing the wrong marker is a long way off from murder and burglary. The prosecution's only other reason to believe that Avery had any intent to commit an act of vandalism was a screenshot sent to Detective Markowitz from Alex Cifuentes, purportedly displaying a text conversation in which Avery said she'd commit vandalism. However, you heard from Detective Markowitz himself that they only reviewed the screenshots from Cifuentes' phone, but never downloaded the contents, meaning that Markowitz has no way of being sure these texts were from Avery. Not only did Avery have no motive, but she also didn't have the opportunity. Today, you heard from Taylor Perkins, who testified that they were with Avery at the time of the break-in and murder. Taylor and Avery were retracing their steps all day at the mall and at Fry Shack, looking for Avery's phone, which had been lost the day before. However, Detective Markowitz cut this corner as well and never investigated this alibi, failing to interview any witnesses at the mall or Fry Shack. The prosecution attempts to claim to know Avery's whereabouts at the time of a murder based on cell phone towers. Besides there being overwhelming evidence to support that Avery did not have her phone at the time, Professor Van Owen has explained today that cell tower data is not remotely analogous of GPS information. It's not accurate to track the location of a cellular device, so we don't actually know that the phone was even near Brackman's house. Furthermore, if we were to assume that the cell phone had connected to the nearest tower, the particular tower near the victim's residence covers an extremely wide area. Overall, Detective Markowitz's conclusions that Avery was near the crime scene cut so many corners that it no longer even resembles something close to the truth. Detective Markowitz also failed to properly investigate the murder weapon, one of the central elements of the prosecution's theory of the crime. Although Markowitz testified that the knife came from the crime scene, either from the knife block or the drawer, the murder weapon doesn't match any of the knives in Brackman's kitchen. This implies that whoever perpetrated this crime brought the knife to the crime scene with the intent to kill Master Brackman, rather than picking it up from Mr. Brackman's kitchen. The prosecution agrees that Avery had absolutely no motive to kill her mock trial coach. Therefore, whoever brought the knife to the crime scene could not have been Avery. Professor Van Owen has also shown you several holes in the prosecution's theory of how the murder actually occurred that the prosecution literally ignores. The prosecution claims that there was evidence of a struggle at the crime scene, but their only actual evidence of this is some scuffing on the floor. However, they do not show that the scuffing was a result of a struggle. It could have been on the floor before this. Valuable items had been left undisturbed. There were scissors on the chair next to where Mr. Brackman was sitting. He would have grabbed the nearest sharp item closest to him if he saw the perpetrator coming. This is all consistent with the truth that the perpetrator of this crime came to Brackman's home with the sole intention of murdering Mr. Brackman, which the prosecution agrees could not have been my client. Overall, what every piece of evidence in this trial has culminated to is that Blair Rowlands, not Avery Becker, is the perpetrator of this tragic crime. Blair Rowlands' father, Jonathan, was a former client of Mr. Brackman's who ended up being convicted of murder and sentenced to life in prison. We've shown you a chilling audio recording of Jonathan Rowlands yelling out that Brackman was going to die for sending him to prison. This is a significant motive for murder, which, as we've demonstrated, the perpetrator of this crime possessed. Blair Rowlands also had the opportunity to commit this crime, as she is the same build as Avery, was absent from school on the day of the crime, and disappeared after graduating from Colorado High School. The prosecution did not look into Blair Rowlands. Today, the burden of proof is on the prosecution. At the beginning of this trial, my co-counsel asked you a question. Can the prosecution prove beyond a reasonable doubt that Avery was the one who broke into Mr. Brackman's house and killed him? At the end of the trial, the prosecution has showed you that they cannot. Through their assumptive logic, incomplete investigation, and general corner cutting, you can see that the prosecution has failed to meet their burden. Thus, we ask you, the jury, to find Avery Becker not guilty of second-degree burglary and first-degree murder. Thank you.
Your Honor, may I ask the timekeeper how much time I have remaining?
You may.
You have 2 minutes and 10 seconds.
Thank you.
Please proceed.
Ladies and gentlemen of the jury, let me remind you that today's trial is that of Avery Becker. This is not a hearing or an investigation. We are not looking for leads or possible suspects. We are looking for the guilt of Avery Becker. And in that same vein, this trial is not about Blair Rawlings or her father. This trial is about Avery Becker. And as such, let us treat the evidence presented and the testimonies presented in today's trial within this framework. And that framework is as follows. The defense has not disputed the logical claim that I laid out before you in my closing. They did not dispute whether or not Avery Becker committed these crimes. So when we look, we see today a case that is built upon a solid foundation, one that is built by the bricks of logics, fact, and evidence, one in which no corners were cut. However, when we look to the defense, we see a foundation sinking under the weight of a flawed and paid-for testimony, that of Professor Van Owens, and the incomplete and frankly immature testimonies of the two teenagers the defense brought before you today. Therefore, we can only stand upon the foundation that we, the prosecution, have laid out before you, one in which Miss Becker is guilty. She is guilty of criminal mischief, second-degree burglary, and most importantly, first-degree murder. Thank you.
Okay, normally in a real trial, this would be submitted to the jury and the judge would read instructions or otherwise provide instructions to the jury. And thankfully, we don't have to do that. But this proceeding will be deemed submitted at this point. And I think the main thing that means, at least right now, is everybody can relax. Kind of sit back and let's wait for the scoring panelists to finish their scoring and submission of their score sheets to the, I guess, to the courtroom monitor. And after that, let me ask the teams, this is the fourth round, and typically, the general rule is that there will be no feedback critique session after the fourth round. But I have I have a few comments I'd like to make, and I don't know about the scorers, but I typically they do have some comments, and if the team would like, but only if you would like, I will give the scorers an opportunity to make a few brief comments. I would like to make a couple brief comments myself, but if you'd rather just go home or do whatever else you have planned for the afternoon, all of us will understand. So let me know, do you want to hear some brief feedback from the scoring panelists and from me?
Personally, Judge, I would love to hear some feedback. I feel it is always constructive, and I could also pull this into the mock trial for next year. So that is a yes, one vote for yes.
Okay. Well, let me ask it this way. Does anybody just want to get the heck out of here and go and listen to the, find out the results? Okay, hearing none, and I guess I will ask our scorers if you are willing to provide some feedback on this presentation this afternoon.
I'd be happy to.
Okay, looks like we're on. Let's wait for the confirmation that the panelists have all submitted their score sheets, and then we'll proceed.
Your Honor, all scoring sheets have been submitted.
Okay. Let's start the feedback with the ponytail kid here. Roger.
I'm not a kid anymore. I'll be brief. That was fantastic. I only have positive feedback, so you'll have to prepare for next year. Otherwise, first of all, as far as mock trials go, this one knocked it out of the park. It was probably the most dynamic that I've seen in years, and I'm sure I've seen probably about a dozen of these at least by now. The exchanges on objections were excellent. There were objections to hearsay and leading. There were objections on and challenges on voir dire. There were cross-examinations that involved just back and forth and people pounding away and holding their ground. And that was seen throughout this mock trial. So in terms of just being a spectator, it was probably the most entertaining one that I've seen ever. And it's because of the engagement. So also, I just want to point out that I saw something here that also struck me as rare, and that was really good listening skills. The lawyers and the witnesses, but the lawyers in particular, were listening to what the other side said and reacting to it. You know, so often you get stuck on your plan to, I'm going to ask this question, then I'm going to ask that question, and then you just try to move down through your list. But the fact that everybody was listening to what the other side was saying and then holding them accountable for their exact words at times was fantastic. So my final remark is that you were all energetic and engaged. And, you know, I've had 2 of these this week. I don't know how many exactly you all went through, but to be able to pull that kind of energy and enthusiasm, engagement and listening, and the parlay back and forth at, you know, this end of the tournament was also really commendable. So great job. Great jobs to you all.
Marie, would you like to comment?
Yeah, sure. Like Roger said, everyone did an amazing job. The objections definitely, compared to the other trial watch, you guys really knew all the different types and everyone was responding really well to them. Grace under pressure, which is amazing. I know it's always so stressful when someone all of a sudden objects and you have to think on your feet. In general, just like a couple of comments for the prosecution's opening, you guys have to state the burden of proof and like what you have to prove, like the elements of the case. I didn't really hear that really straight up stated and what's going on. This was a comment just for everybody. A lot of the attorneys kind of responded to what the witnesses said, like, okay, or thank you. And I know I do that too. But it's better if you kind of try to practice and not do that as much. Hard to do. And what else? Like I said, everyone did great. I thought all the witnesses were really good at trying to get around the cross yes or no questions. I think there were sometimes when you guys explained a little too much and you could have been a little more succinct and it would have gotten the same message across of, you know, you're right, but this is wrong. And I'm standing by what I have created or the facts I've determined in this case. And another comment was just to kind of review the impeachment process. Because like Roger said, you guys were really good at catching when people were saying improper things, but just make sure to go through the whole, did you make a statement? Would you remember it? Can you, I show it to you, and all the different steps. But overall, great job, you guys.
That's what they always say. They say overall, great job.
Next.
I think that's me. Well, first off, you guys did an amazing job. And if I was half as good at mock trial when I was your age, I probably would be a better attorney now. So kudos to all of you.
Okay, I'm sorry, there's someone, we're getting some outside noise. Could anybody who is not speaking, please mute your computer? Sorry to interrupt.
You're fine, I get it. So just a couple of things. I could tell all of the attorneys and all of the witnesses, you really knew the materials. You guys weren't looking at your notes, you guys weren't stuttering, but what happened was you were going a little bit fast. I do the same thing. When I know what I want to say, when I'm passionate about what I'm saying, I get really, really excited. So just practice a little bit slowing down. Taking a deep breath and pausing is not the worst thing in the world. It may seem like the longest breath in your entire lives. I promise you, nobody else in the room notices how long it feels. So take a moment, let the point you've made really sink in for your jury, let it really be emphasized in your silence, and then move to your next point, because you guys are so energetic, so fast, and it was hard sometimes to keep track of all of the information. But overall, that's a good problem to have. You're getting it all out there. Also, be very careful about not talking over each other. I know you guys want to have good witness control, especially on cross-examination, and you've got some hostile witnesses at times. With Zoom, it's really important to not talk over each other, and that's just a skill that we all have to learn. It's, those of us who are doing bench trials over Zoom, we suck at it too. Also, great use of tech though. Like, really impressed with you guys sharing the exhibits, being able to know exactly what you wanted to look for. I struggle with that day to day when I'm doing hearings on WebEx. I know other attorneys do too. So you guys are really, really killing it. So really, really great. I thought you guys, both teams had a great theme. I could tell what it was from the get-go, and I could see it, kind of woven in all of your testimony, your openings, your closings, everything. So overall, good job. You guys should be really proud of yourselves, and your coaches did a great job helping you guys get ready.
Deanna?
Thank you all for being here. Thank you all for having the mental and physical fortitude of hanging in there for this long to get to this stage. What you have done is absolutely incredible. Do not discount that. No matter what the results are of this tournament for this weekend, do not discount your hard work. You have put in tremendous effort, and that is incredibly apparent. As Mr. Wertheimer said earlier, this has been phenomenal today, especially this round. I have seen everyone progress. I've been volunteering for this entire tournament. I have seen everyone progress from the very beginning of the case up through final utterance at close. I can see that. I can see the work that you guys are putting into yourself. I can see yourself mentally correcting yourselves and carrying on with whatever it is that you have to be doing at that moment, be it attorneys or witnesses. It does not matter. We can actually see you improving as you go through these cases. That being said, yes, please practice these things in front of a mirror. You will get better at slowing yourself down. I do agree with Ms. Legel. When you just simply stop to pause, to recollect your thoughts, the rest of us don't notice that, and it actually serves a purpose to reground yourself. So keep that in mind, future use. The talking over each other, don't be upset with yourself for doing that today. Yes, it is difficult, especially in these web-based situations, but I have actually seen a court reporter yell at attorneys because they were talking over each other, and the judge actually laughed and said, "I told you so, knock it off." So don't get too upset with doing it yourself today, but just try to be more mindful of that. As far as things that have happened today, I want to say that all of the witnesses specifically, I don't think you guys normally get enough attention on this. I think each and every one of you knocked it out of the park. You stuck to your statements. You did your best to confound these attorneys. And by the way, to the attorneys, nice job pulling them back in. Your objections were fantastic. Your direct was great. Crosses were wonderful. I think everybody involved in this courtroom today pulled off beautiful performances. Be proud of yourselves. Take that into however it is that you choose to go from this point forward. But you're awesome. Don't forget that. Okay. Have a great weekend and good luck.
Okay, thank you all. I will confess that most of what I was going to say has been said, and I would echo it. This was I'll just echo it, I won't repeat it. But this was, I have to tell you this round was one of the reasons that I do this, that I volunteer. It was a very close round, good opponents, passion, emotion, as is appropriate for a murder trial. Well coached, both teams, and very well prepared. There's lots of evidence of the hard work that all of you put in. And I won't belabor that, but believe me, it's unanimous among us that this was a great round. I would like to mention a couple of instances in particular of why I enjoyed this. And one of them was the closings. Both closings were very similar. As I am looking at my notes now, both attorneys did a good job of bookending, that is, repeating the theme in the closing that was raised and essentially argued in the opening. And I particularly liked the something I've never heard before in this context, and that was references to Sophocles and Antigone. And it took me back until I pulled myself forward to my college days and reading Antigone and the poor old Creon. But that was the theme in the opening and the closing. And furthermore, the closing by Katie for the defense. You did a great job of picking up on this, and I wrote it down and I put it in quotes that you said you were talking about the prosecution's case, and you said, "This is mythology." What a great job. I mean, that is absolutely wonderful. And what we look for, I look for as a volunteer in this program. Just a fantastic job. And there was good substance to both closing, good passion. And as I said, that's appropriate for this kind of a proceeding. The other thing I'd like to mention briefly, one of the reasons I especially like this is to observe the cross-examinations. And as has been said, these were uniformly excellent cross-examinations, but the one that I particularly took note of was the cross-examination of Emily by Katie. And it was kind of a classic battle that you see in real life for control of that process, of the cross-examination process. And Emily, it was back and forth. And really both of you absorbed some body blows, but you came right back. And pretty soon you were giving the body blows and the other participant. It was just, again, a wonderful thing to watch. I had fun observing that as well. So I could say a lot more, but much of it's already been said. I do want to give a shout out to the people who would otherwise be in the gallery if this was a live rather than a Zoom presentation, the coaches and the families and the teacher sponsors for these programs. And if I don't know if they can hear me now or see me, but I would like the students to pass this on to them. They are almost as important to this process as the teams are. They are the support folks. They allow you to come home late for dinner, stay up late, not doing your homework because you're doing work on mock trial. And they are the ones that give you the attaboys or the attagirls. And I personally want to thank them for their contribution to this overall program, to the excellence in particular of these two teams. So please pass that on if they're not hearing me directly. Well, that's enough. You're tired. It's been 3 long days for you, I know. I'll let you go find out the results. But whatever they are, whatever the results are, I want both teams, excuse me, to feel a real sense of satisfaction about your performance in this round. Uniformly excellent. So thank you all for that from me personally, as well as from the program itself. You are the reason that this program is so successful. So thank you and good luck.
All right, and a brief thank you for our judges. I understand there are many other things you could do with your Saturdays, and you're scoring our judges, scoring our debates, and that's super helpful. So I just want to thank you all for your time today. I very much appreciate it. So have a great rest of your